Yeah, say. Yes, please.
I pray for little recommendation for item number 30.
30.
30.
Yes, what do you want in 30?
Mr. S. Bothakor, he is the concerned counsel. He is now bereavement. So after the vacation.
All right. S for by Mr. Mr. A. Deka, learned counsel appearing for the petitioner on the ground that Mr. S. Borthakur, learned arguing counsel, is in bereavement, relist after 3 weeks on a date to be fixed by the registry.
I recommend getting item number 18, 1-8.
1-8. Yes, what do you want in 18?
This one may be taken after vacation.
After?
After vacation.
After vacation.
Yes.
Your name?
S. Rahman.
As prayed for by Mr. S. Rahman, learned counsel appearing for the petitioner, relist after 3 weeks on a date to be fixed by the registry.
Lordship, item
I cannot hear you louder.
Lordship.
Don't be nervous. Just speak loud. I think you're coming this side. Just face to the microphone.
Lordship,
Yes.
I requested in item number 54 of supplementary list. We filed the IAT.
You want the IA to be called? All right. Yes, please. In fact, any affidavits, IAs to be called, simply tell the court master. You don't have to make a mention before this court. He will call. Rupa, kiba call koribo lagile call kori dibo. Yes, please.
Lordship, I beg to mention item number 12, Lordship. Maybe adjourned for the day. Maybe listed before vacation, Lordship. 126.
Item number
12, Lordship.
12. All right. As prayed for by Mr.
Yes, Hussein.
S. Hussein, learned counsel appearing for the petitioner, relist after 3 weeks on a date to be fixed by the registry.
Before vacation, Lordship, because.
All right, next.
Lordship, NBW was issued, Lordship.
You want accommodation or you don't want? I have given now after 3 weeks. Next.
Okay.
Maybe, Lordship, I recommend item number 14 may be adjourned today.
Sorry?
Item number 14.
1-4.
1-4.
What do you want in 1-4?
Senior is not
Not well. As prayed for by Mr.
Islam on behalf of
Islam, on behalf of the arguing counsel, Mr. J.C. Bora, relist after 2 weeks on a date to be fixed by the registry.
I feel, Lordship, I may be allowed to IA criminal so-and-so for instigating connection with item number 56 and 57.
What do you want?
I may be called.
You want the IA to be called for?
May I please, Your Lordship? I beg to mention item number 45 for hearing.
5.
Yes, Lordship. I'm appearing on behalf of SE Biswas. This matter may kindly be adjourned for a day, Lordship.
45. As prayed for by MS.
KLR Yantan.
A.
LR Yantan.
LR.
Yantan.
Yanham. Learned counsel appearing for the appellant, relist after 1 week on a date to be fixed by the registry. Yes, please call the list. Yes, Mr. Shekhar, what is this bail application that you have come with? This seems to be one from the Manipur, the same.
Yes, madam.
Fine, fine. Item 1.
Yeah.
No, there's a withdrawal.
May I please?
My lord, I may be allowed to withdraw this case to file appraise, my lord. I have to annex some documents, my lord. So I may be allowed to withdraw the.
Your name?
A. Paramani.
Mr.
A. Paramani.
A. Paramanik, learned counsel appearing for the petitioner, submits that the petitioner does not want to press the instant criminal petition and accordingly seeks withdrawal of the same. Prayer is allowed. The criminal petition stands dismissed on being withdrawn. Mr. R.J. Bara, learned APP, is also present.
Kindly with on liberty.
With liberty to file fresh if required.
Highly obliged.
Motion clear, item number 1.
May I please talk?
একেলগে লৈ যাবা এতিয়াই নালাগে
This is a second bail application, my lord.
yes
Uh,
what is the circumstances that has changed
My lord, your lordship, while disposing the bail application, your lordship has held that the grounds of arrest was duly communicated to the arrest team, my lord. And your lordship's observation was there from the remand order passed by the lower court magistrate, my lord. We have verified the lower court records, my lord, but the arrest was nowhere to be found in the records, my lord.
this is not a review
And
second bail application is not a review Mr. Shekhar
what
you
about,
have any grievance you can go to the higher forum
moreover, my lord, I have,
second bail application is very clear second bail application only if there are changed circumstances it
Yes, sir.
seems this is you want a rehearing on the same ground anyway you want to file your objection
Yes, your lordship.
when
After vacation, lordship, because from 28 there is a
on
vacation.
the reopening date
Reopening day.
yes, my lord.
heard Mr. R. Shekhar, learned counsel appearing for the bail applicant. Stop. Also heard Ms. M. Kumari, learned retainer,
Of CBI.
special public prosecutor,
Yes,
CBI.
CBI.
Notice list reopening or at a date, not the first day.
Not on the first day. 16th. Much obliged.
Oh, motion item number 2.
Mr. Shekhar, most likely this application has to come before this court only.
Yes, my lord.
I may not be in station that time, but anyway, it can be through video.
May I please, your lordship? This is an application under 6447 for transfer of the complaint petition, your lordship.
Yes, what is the ground of transfer?
Your lordship, actually, this is a matrimonial dispute, given the color of a.
That cannot be a ground for transfer.
Your lordship,
Yes,
I am the wife. Petitioner number 1 is the wife. And petitioner number 2 and 3 are the mother and father of the petitioner number 1. Your lordship, a DB case is pending.
all right, I am issuing notice right now, nothing else.
Your lordship,
Sorry, it's a transfer petition. Your name,
B. Pushilal, your lordship.
Mr.?
B. Pushilal.
Your name is not appearing here?
Yes, your lordship, I will sign the वकालत में आगे. But my, in this,
Your name is not here. লাগিলে নামবোৰ লৈ ল'ব, huh? তেওঁৰ কাৰণে দিগদাৰ হ'ব। Heard Mr. So-and-so, learned counsel appearing for the petitioner. Stop, this is an application seeking transfer of complaint case number 817/2024 from the Court of Judicial Magistrate First Class Dhubri to Chief Judicial Magistrate Dorong at Mongoldoy. Issue notice. Returnable 2 weeks, steps by registered post AD within a period of 3 days from today, list accordingly.
your lordship, kindly fill the next date. Your
Next,
This is a revision petition by the Union of India.
Mr. Kayal, sorry, this is,
The revision petition filed by the Union of India, challenging the validity of order 76/2025 lordship, whereby bail was granted.
We are yet to be served the copy of the petition.
copy not served, Mr. Kayal.
This is a criminal proceeding, lordship, they file KBA. Lordship not in criminal proceeding unless a notice issued. They are not.
Give a copy, we'll take it up on Friday, Thursday.
Thursday, my lord, I have some difficulty. Friday, it can be.
Okay, Friday. Relist Friday, huh?
Number 4.
May it please your lordship. Yeah, lordship, revision petition, lordship, I challenged the JIMA order, lordship, that was rejected, that on page 31, lordship.
Page,
Page 31, lordship. Here, I am not the lordship accused, neither lordship connected with the alleged offense, lordship.
31.
31, lordship.
You are challenging the order by which the JIMA of the vehicle was rejected?
Yes, lordship.
Yes.
And the register owner, lordship, actually what happened, my son, lordship, riding that vehicle, lordship, and the FIR, lordship, will find on page 17, lordship. Here specifically said, lordship,
Let's first see the impugned order.
yes, lordship.
It is found from the case record, that part.
Yes, lordship.
This is what vehicle? Pulsar, motorcycle.
second para from bottom, Lordship, it is from the case record, the vehicle.
It says
registration.
that police report clearly states that the seized vehicle is required for the purpose of investigation.
Now, Lordship.
Now, what is for what reason? It's a vehicle.
We call for a report, my lord. Lordship may kindly state the date of the order, my lord. It is on 6/5/2025 when it was rejected, my lord. Now it is almost, my lord, more than a one and a.
All right, I mean, you use, I'll call for the report, I'll post it on the immediate reopening.
Yes.
Please get the report without fail, because I don't see what is the reason, why should this motorcycle be? You need it for the purpose of investigation, you take sufficient security and you release. Why should this be? This is not a contraband articles or anything that you need to send for some testing or anything,
No, Lordship.
isn't it?
Moreover, Lordship,
It's a vehicle that the decision of the apex court are very clear.
yes, Lordship. Lordship, moreover, Lordship, in the FIR, Lordship, it is stated the seized item was recovered from the jacket of the person, Lordship, not from the vehicle,
He
Lordship.
was, and what was the item?
Heroin 27.43 grams,
So
Lordship.
this is, the allegation is that that person was riding this.
Yes.
Vehicle, that is the.
What is the purpose of investigation, Mr. Bora?
My lord,
Yeah,
we'll just call for a report, my lord, only to know that, my lord.
Get a first day,
Request
opening
for
or
separate-
first day deliver. Call for report from?
From Lordship special.
I have.
Yes,
My
call
lord,
for
from
report.
Bihali, my lord.
Huh?
Bihali PS, my lord.
Bihari,
Bihali PS, my lord.
Bihali Police Station,
My
from
lord.
the jurisdictional Bihali Police Station. List on such and such date.
I live.
It is needless to be, just add this, it is needless to be clarified, considering that this is the subject matter is the seized motorcycle. The report call for shall be positively placed before this court on the next date of listing.
I
Yes.
live.
May I please? My lord, this is criminal revision petition, my lord, against
Revision against which order?
order dated, my lord, page 34, my lord.
Page 34.
Yes, madam.
Yes,
9/5/2025. And this appeal was by this order, my lord, the conviction was upheld by the.
conviction for how many?
1 year, madam.
One, yeah.
But this is-
Offense is
Offense is 354, my lord.
354. Yes,
So at this moment, my lord, your lordship. is-
notice.
Notice and the
And
suspend.
are you on previous bail?
Yes.
Then we continue.
LCR may be called for.
Mr. Bora, in case I forget, you just remind me when I'm dictating, just,
My lord.
yes. All right, Mr. Payang,
Yes, madam.
G Payang,
They're fine.
J Payang, learned counsel for the petitioner, stop, also heard Mr. RJ Barua, learned, Barua, Barua, learned APP for the state respondent. This application is filed under section 442 BNSS, read with section 438 BNSS 2023, seeking quashing of the order dated 2/5/2024 passed by the learned Chief Judicial Magistrate Majuli in PRC number 54 of 2023, within bracket GR case number 160/2023, Majuli PS case number arising along with within bracket 66/2023, whereby the petitioner has been sentenced to undergo simple imprisonment for a period of 1 year under section 354 IPC and to pay a fine of rupees 10,000, and in default, simple imprisonment for 3 months, and the judgment dated 9/5/2025 passed by the learned session court Majuli in criminal appeal number 3 of 2024, whereby the criminal appeal filed by the petitioner was dismissed and the sentence passed by the trial court was confirmed. This, the details you will get in the cost title, which is at page 1. Okay, just cross check. Issue notice, returnable 2 weeks. Mr. Borwa accepts notice on behalf of respondent number 1, extra copies within the course of the day. Steps by registered post AD in respect of respondent number 2. Within a period of 2 days from today, steps. Mr. J. Payang, let it counsel for the petitioner submits that the petitioner has been on bail during the period of trial as well as the appeal, and has not done anything and has not taken any undue advantage of the bail granted to him by this court. Bail granted by this court, Mr. Payat?
By my lord.
By the trial. Okay. In view of the aforesaid submission, the petitioner is allowed to remain on previous bail. Call for case records from the trial court as well as the appellate court.
Sentence may be suspended.
In view of the fact that the revision has substantial ground, these impugned conviction and sentence is also suspended till further orders.
Item 6.
Sorry. Inside here. Yes.
My lord, this revision, my lord, by sealing the impugned final order passed in, my lord, FC criminal case number 509, page 74, my lord.
Page, impugned order is at page
74.
74. Yes.
Final order passed on 30th of May 2025. And my lord, the response.
Conviction for how many years?
Not conviction, but it is maintenance allowance.
Maintained.
Maintenance. My lord,
How much?
my lord, 7,000 each. Wife.
All right, notice.
Lordship.
I'm not going to stay that.
Without, my lord, any.
Right, let them
any
appear
justifiable
first.
reason,
Let them appear first on the returnable date. This court shall consider your interim.
Without justifiable reason, she had left my matrimonial house.
All right.
After 13 years of peaceful.
You are the
life.
admitted husband or not?
Husband.
All right.
But she.
Heard, Mr.
Ke bhuya, lord.
Mr.
Ke bhuya.
K. Bhuya, learned counsel.
she's
for
the- she's the
Mr.
army-
Counsel, I'm dictating the order.
The
Please
army
take
lady.
your seat now. So and so, learned counsel for the petitioner, stop. This is an application under section 438, read with section 528 of DNSS 2023. Seeking modification stroke alteration of the impugned final order dated 30/5/2025 in FC criminal case number 509/2022 under section 125 CRPC, passed by learned principal judge, family court, Borpeta. Issue notice, returnable 2 weeks. Mr. Barwa accepts notice on behalf of respondent number 2, but you have to accept, they've arrayed you as a respondent. Extra copies and for the private steps by registered post AD.
Interim, my lord,
Uh,
interim prayer may be given.
Into the list after 2 weeks as they did on such and such date, interim to be considered on the next date. However, it is needless to be clarified that the maintenance as directed by the court, by the appellate court. This is against the order of the
Family court.
family court shall be complied till then. Yes.
Met with the loss. My lord, this petition is against the order of the landed land grabbing tribunal.
Of?
Landed land grabbing tribunal in Guwahati, my lord.
Yes.
The impugned order was judgment, my lord, at page 79.
Impugned order is at page 79.
Yes, ma'am.
Yes.
I beg to draw your lordship attention to two parts of the matter which speaks about the circle officer's report, which was called for by the tribunal. In this connection, I draw your lordship attention to page 84.
Just let me just have a look at the impugned order first.
Should I read it from the beginning?
No need. What, it's a short order, I think.
It's a bit long, my lord.
Relevant portion.
Relevant portions, I beg to draw page 84, your lordship.
1 second. 84.
84, my lord.
Yes, please.
Paragraph 6, my lord. If your lordship might have got it.
1 second.
A bare perusal.
1 second. 1 second. Yes, 84.
A bare perusal of the said report dated 11/3/2025 reveals that said report is almost true copy of the earlier report dated 1/8/2024. However, it is relevant to mention here that in the said report dated 11/3/2025, it is categorically stated that the applicant had submitted a copy of the sale deed, being deed number so-and-so dated 22/10/2019. It is also stated in the said report that the schedule of the land of the applicant in the sale deed is not matching with the land in possession of the applicant. However, two portions are shaded colored in the trace map provided by the circle officer along with the report, which were also there in the earlier report dated so-and-so. And it appears that the said portions of the land have been referred as the land in possession of the applicant and disputed land. The disputed land has been shown in the gray color in report so-and-so. This is the report submitted by the circle officer. Now I beg to draw your lordship attention.
Let us finish it. Let us finish it. Applicant was evading. Let us finish it.
My lord.
Let us finish the order.
However, a bare perusal of the schedule of the sale deed dated 22/10/2019 reveals that the gray color shaded portion land is not the schedule of the land in the sale deed. Accordingly, this court sought clarifications of the applicant as to which is the actual plot of the land purchased by him. The applicant was awaiting clear answer and submitted that the said gray color shaded portions of the land along with some portions of red color shaded portion as shown in the report dated 11/3/2025, that is circle officer's report, my lord, was given in possession to the applicant on execution of the sale deed by the sellers, who are respondent 1, 2, 3, 4, and 5. The applicant further submitted that the said sellers sold property in the same dark numbers.
Cognizance was not taken.
My lord,
Cognizance was not taken.
cognizance were not taken, my lord, and rather your lordship
And
can
it was
see
dismissed with cost of rupees 5,000.
5,000. So, my lord, at this stage, the notice may kindly be issued and the imposition of fine may sort of temporarily suspended, my lord.
My lord, this is a immediate revision petition, my lord, so jurisdiction of this honorable court is very limited, my lord.
I'll issue
Because-
notice, not a
Issue-
difficulty.
It is maybe issued, my lord, let the opposite party appear, my lord. After that, my lord, his interim period may be continued. my lord.
Heard Mr. M.H. Rajbar Bhuya,
Yes.
learned counsel for the petitioner. Stop. Also heard Mr. R.J. Barwa, learned APP for the state respondent. By way of this application under section 528 of the BNSS 2023, the petitioner is assailing the order dated 23/5/2025 passed by the additional session judge number 1 Kamrup Metro Guwahati in special land grabbing case number 44 of 2023, whereby the trial court has refused to take cognizance of the matter. Inter alia. Issue notice, Mr. Barwa accepts notice on behalf of R1, extra copies, register post AD in respect of respondent number 2 to 12. 2 to 12.
Yes.
Within 3 days from today. And list on after 4 weeks, 3 weeks. I think that 12 respondents, 3 weeks.
Yes, my lord.
3 weeks and interim to be considered at the on the returnable date. Yes.
Your matter is, I guess, the impugn order dated 7/3/25, Your Honor. The order
Just
was-
1 second, Rupa. তুমি পিছত কি কৰিবা সেই পডিয়ামটো অকমান সেইফালে ঠেলি দিবা তাৰমানে এই কম্পিউটাৰটো যে আছে সো সেইটো সাইডে মই ক্লিয়াৰ ফেসটো দেখা পোৱা নাই Yes, please.
Order passed by the Judicial Magistrate First Class, Karbi Anglong Difu, Your Honor. Under the petition.
Page, page number.
Yes. Order is, Your Honor, in 26, page number 26.
26. One second, let me get to 26.
Page number 26. Your Honor.
Yes, now operating part, where do I get the operating part?
Your Honor.
So 1 month conviction, my lord.
1 month.
1 month conviction under section 323 IPC, my lord. 323 IPC, 1 month, my lord.
And where
Yes.
was on bail.
1 year, my lord, under section 354 IPC, my lord.
So
Convicted
during,
by trial court and affirmed by the appellate court, my lord.
during trial bail.
Yes, my lord. Bail of-
All right. Yes, your name, Heard MS
I will send you.
Goswami. Learned counsel for the petitioner, also heard Mr. R.J. Barwal, learned APP for the state respondent. By way of this revision petition,
Your Honor.
I'm giving you, you sit.
No, okay, Your Honor, but I have another submission, Your Honor. I think I have made mistake. I have not made the government party, so I have to do.
Huh?
I have made the, not made the government as a party.
কি কৰিলে?
He has not met the state of Assam as a party, my lord.
All right, you change it.
But it's a, it was a state of Assam.
Relax, now you sit down.
This is not your case number, so petition number 8.
I'm sorry, my lord, this is our,
Petition number 8.
but demand number, I think.
8 number.
What is the confusion, Mr. Barwal?
Item number 8, Your Honor. My one.
This is criminal revision petition
I-
230.
I'm sorry, my lord. We are not party here, my lord.
My one is criminal number,
I'm
it is
sorry.
item number 8, Your Honor.
This is criminal revision petition 230.
Yes, yes. Page number 26 is the.
Yes, I have 26.
Page number 26 and the order is reflected, final order is reflected in page number 86, Your Honor. Page number 86. The order is according to the court deems it appropriate to direct the second party to pay a sum of rupees.
Maintenance.
Yes, Your Honor.
You are appearing for the husband.
I am appearing for the husband.
Much maintenance?
It is
6,500. Okay, I'm only issuing notice, ma'am, right now. Interim next after returnable, okay? Heard MS R. Goswami. R. Goswami, learned counsel for the petitioner. By way of this application, the petitioner is assailing the impugned order dated 7/3/2025, passed in miscellaneous case number 2/2024, passed by the Judicial Magistrate First Class Karbi Anglong, Diflu, Assam, whereby a maintenance of rupees 6,500 was awarded.
for
Stop.
per month. For per month.
Hmm?
Per month.
Per month was awarded. Issue notice, returnable 3 weeks. Registered post AD, list after 3 weeks on a date to be fixed by the registry. Interim prayer to be considered on the returnable date. Yes, Mr. Barbuya.
Yes, may I be? My lord, this is a criminal revision petition, my lord, filed before your lordship. After my lord dismissal of the appeal by the learned session judge. My lord, it is a case under Negotiable Instrument Act, my lord. Here, my lord, petitioner is willing to, my lord, settle
6
the,
months
yes, my lord.
Conviction
Already-
6.
Already arrested also, my lord.
arrested.
Arrested, my lord.
During trial, you were on bail.
After the judgment of the appellate court.
No, no, during trial, you were on bail.
Yes, on bail.
And during appeal,
Bail, my lord. He also interested to settle the matter, my lord. He is also, my lord, interested to settle the matter with the, my lord, complainant.
what is the ground of challenge?
challenge is that, my lord, in this case, my lord, the judgment was passed basically on presumption, my lord. Lordship, kindly have a look, my lord, page, paragraph, my lord,
After you filed this revision, you were arrested
during the period of revision, my lord,
during the
period of limitation, my lord.
limitation. No, because you are now not filing a bail application.
Yes, my lord, I have connected bail application is there.
IA is there.
Yes, yeah.
No, IA too.
He is a 63 years old person.
Where is the earlier bail order?
Earlier bail order, my lord, I have not annexed, my lord.
Mr. Barwa? The IA can be disposed of by allowing the petitioner to go on bail. He was arrested, though he was earlier on bail.
My lord.
But
Yes, my
after
lord.
the appeal,
And I,
because as far as the main case is concerned, I'll issue notice.
yes, my lord.
And suspension we will consider after the party appear.
To the party.
But this bail can be disposed of, I think.
No, I am, my lord, that suspension has to be, my lord, sentence has to be suspended, my lord, then, my lord, he may be allowed to go on bail. Suspension.
So then I will issue notice board, and in the meantime, bail prayer can be granted as an interim.
Yes,
That I leave it to your lordship, my lord, because it's an case, my lord. Came
because
procedural.
Because he does not have any criminal antecedent.
yes, sir.
Your doesn't.
6 months,
For much you're gonna do.
6 month punishment and 6 lakhs compensation.
6 months and 6 lakhs.
LCR may be called from, my lord, and let the opposite party appear.
But this can be disposed of.
If the IA dispose of them, my lord, he will.
In fact,
He will be allowed to go on bail, my lord. Lordship will have to allow or reject, my lord.
Considering it is 6 months,
6 months, basically, my lord, it's granted, my lord.
that's why. And he doesn't have any criminal background. But in that situation, the IA has to be disposed of,
Yes, IA.
isn't it?
Without disposing of the IA.
Right. First, you take down in the IA, huh? Heard Mr. A.M. Barbhuya, Learned Counsel for the applicant. Stop. By way of this application under 438 of BNSS 2023, read with section 430, the petitioner, the applicant is seeking allowing the accused petitioner, i.e. Bidhan Chandra Roy, to go on fresh or previous bail, staying suspending the impugned judgment and order dated 6/3/2025, passed by the Learned Additional Session Judge Hailakandi in Criminal Appeal number 6 of 2024, which was affirmed by the impugned judgment and order dated 30. No, which was affirmed, no, which affirmed, okay, not which affirmed the impugned judgment and order dated 30/12/2024, passed by the Learned Additional Chief Judicial Magistrate Hailakandi in NI case number 61 of 2019 under section 138 of the NI Act. The brief facts of the case is that the applicant was convicted by judgment and order dated 30/12/2024, passed by the jurisdictional magistrate court in the above referred NI case, whereby the applicant was sentenced to undergo simple imprisonment for a period of 6 months under section 138 of the NI Act, and also to pay a fine, pay a sum of rupees 6 lakhs as a compensation. Stop. It appears that against the aforesaid conviction, an appeal was filed before the learned additional session judge Hailakandi, which was dismissed. Stop. However, during the statutory limitation period of 3 months, the applicant was arrested on 25/5/2025, and since then he is he's in jail. Stop. Situated thus, the present interlocutory application has been filed along with the accompanying criminal revision petition. Heard, perused. It appears that during the pendency of during the trial as well as the appeal period, the applicant was on bail and has not done any act to hamper the investigation. It further appears that the applicant does not have any criminal antecedent. Stop. Further, the grounds of challenge appears to be of prima facie substantial. Accordingly, the applicant is allowed to go on previous bail.
Previous ballot, he is inside my lord.
You say accordingly, the impugned judgment and order dated 36/3/2025, passed by the learned additional session judge Hailakandi in criminal appeal number so and so, which affirmed the impugned judgment and order dated 30/12/2024, passed by the learned additional chief judicial magistrate Hailakandi in NI case number 61/2019, shall remain suspended until further orders. Stop. As resultantly, the applicant is directed to be released forthwith on the furnishing of bail bond of rupees
6 lakhs.
50,000.
60,
50,000.
50,000 to the satisfaction of
My lord, it would be, my lord, satisfied the CGM, my lord, Hailakandi.
GM
CGM Hailakandi.
Hailakandi. Any other condition?
Any other condition he may, my lord?
With any other condition as the jurisdictional magistrate court may deem fit and proper.
Fine.
That's it. IA stands disposed of. Now, in the main criminal revision petition, you simply say notice, returnable 3 weeks, registered post AD, call for case records of trial court and appellate court, and list after 3 weeks and a date to be fixed by the registry. IA is disposed of, huh? Yes. Revision against
Lordship, the order or judgment dated 26/5/2025. The impugned order is at page 21, Lordship. The relevant portion will be at page 29.
Maintenance,
Maintenance, under section 125, CRPC.
16,000. All right, notice.
Grievance is that the son was not given maintenance beyond.
Let them appear. I cannot give you that order today. Issue notice. Returnable 3 weeks, steps by registered post AD. List after 3 weeks and a date to be fixed by the registry. How many respondents? One? Give his name. Yeah, please give your name, huh? Art so and so. এইটো নহয়। Problem, মানে ঠিক নহয়।
1 month
পঢ়ি
and
পঢ়ি যায়।
conviction, 1 month and 1 year, my lord.
1 month.
1 month and 1 year, my lord.
1 month
Under
and
section 23 and 1 year is under section 354.
you were on bail
Yes,
during
yes.
the whole period
Yes.
of trial and appeal. You are still continuing.
Yes.
All right, Mr.
Chair,
Barwa.
may we call for my lord?
Yes. Mr. Barwa, you see, sometime what happens during dictation, I forget.
My
So
lord.
you stay alert when I'm dictating. If you see something is
Actually,
missing,
my lord, in that case, my lord, we have not been made party because it is an 113 matter. my
that's
lord.
all right.
I do not know about the facts of the case. my
No
lord.
problem.
No,
no
no,
problem.
state of.
But as an officer of the court, I took your assistance.
My lord. More to continue.
Yes. Heard, Mr.
A. Ahmed.
Huh?
A. Ahmed.
Mohammed, learned counsel for the petitioner. Stop. Also heard Mr. R.J. Barwa, learned APP for the state respondent. By way of this revision petition, the petitioner is assailing the judgment and order dated 3/6/2025, passed by the learned session judge Chirang Kajalgaon in criminal appeal number 15/2025, affirming the judgment of conviction and sentence dated 28/2/2025, passed by the learned additional magistrate first class Chirang in PRC case number 58/2021, whereby the petitioner was convicted under section 323/354 of IPC. Stop. Issue notice, returnable 3 weeks. Mr. Barwa accepts notice on behalf of respondent number 1, registered post AD in respect of 2 steps within 2 days from today. It appears that the petitioner has been sentenced by the impugned conviction and sentence order for simple imprisonment of 1 month in default of payment. In default of payment,
7 days. In default of 7 days.
in default of payment,
Impugned judgment in order dated 3/6/2025, my lord.
wait, was sentenced under section 323 of IPC to suffer simple imprisonment for 1 month and in default of payment, another 7 days. And petitioners number 1, 3, and 5 were convicted under section 354 of IPC and sentenced to undergo 1 year rigorous imprisonment with a fine of ₹2,000, and in default of payment, they for simple imprisonment for another 15 days. Full stop. First, that 323 is petitioners, huh? Say petitioners. And the next 354 is only petitioners 1, 3, and 5. You will find it in the cause title. Mr. So-and-so, learned counsel for the petitioner, submits that the petitioner has been on, petitioners were on bail during trial as well as during the period of appeal and are still continuing on bail. However, in view of the fact that the appeal has been dismissed, the present petition has been filed seeking suspension and allowing the petitioners to remain on previous bail. Stop. considering that the petitioners have not done anything, has not taken any undue advantage of the bail granted to them by the trial court. This court allows the petitioners to remain on previous bail pending adjudication of the instant criminal revision petition. Call for case records, so and so, from trial court as well as appellate court, list after so and so.
There is I, my lord, I may be disposed of, my lord.
There was a separate IA.
Yes.
So the IA stands disposed of when I can simply do that, I think.
So I may be disposed of, my lord, but suspending the sentence and allowing to
In
remain.
view of the order passed in so and so, the IA stands disposed of, directing suspension of the impugned, just give that order, huh? Disposed of. 12, it is 12 asil nahi, 11 asil. Masha, this, you show me, huh? Maybe we will convert this to the IA, because I disclosed of the IA. We check when you type it, we just come to the one. One second, Mr. Counsel. Yes, please. What is this criminal petition? What do you want? What quashing are you seeking?
Non-bailable warrant of arrest.
Huh?
Against the order of non-bailable warrant of arrest.
Non-bailable warrant.
Yes, my lord.
Why was it issued? You did not appear.
Yes, my lord.
Why you did not appear?
I have explained, my lord, at paragraph number 10.
What is the explanation?
My lord, the conducting advocate of the petitioner, my lord, has expired, my lord, way back, my lord. That's why.
So you missed the
Due to
date.
yes, my lord. Due to communication gap, my lord, he did.
How many dates did you miss?
3-4 dates, my lord. Already, my lord, he was in bail, my lord. That is
Your lordship may kindly come to page number 16, my lord.
16, my lord. He was released on bail, my lord.
17/4/2023, my lord, he was released on bail, my lord. Page number 16, my lord.
1/6.
Yes,
1/6, my lord, yes. My lord, last paragraph, my lord, page number 16.
Yes,
He was allowed to go on bail, right, ordered it at 17/4/2020, my lord.
20.
Before COVID, my lord. Now, my lord, after that, my lord, he has not annexed all the orders. Now, my lord, he has come, definitely, my lord, he has not
Yes,
appeared, that is why
Speak for
NW has been issued, my lord.
Let the APP speak, yes?
Yes.
My lord, after, my lord, 2020, my lord, he has not appeared, my lord.
And
That is why, my lord,
ultimately, which is the order, non-bailable warrant?
ultimately, lordship may kindly see, my lord, to page number 17, my lord, next paragraph. So during 2020 to 2024, what happened, we do not know, my lord.
But one thing can be done if you, Mr. Barua, because there is no point of keeping this matter pending here, right? So we can dispose of this petition by saying that in case he appears, the trial court is at liberty to consider his prayer for bail,
Yes,
isn't it?
My lord.
That let the because trial court is the best
My lord.
the authority right now to assess whether he, as regards it, because he has been not appearing, why should we keep this matter pending here?
My lord,
He will
that
be-
may
he will
be
appear.
disposed of, my lord.
On 27/6, my lord, the matter has been fixed for appearance, my lord.
And
27/6.
that's why you have come now.
Yes, my lord.
Because that will become.
Yes, if he appears, my lord, he will be arrested, my lord. That protection may
That's
be.
why, no, I'm not giving any protection. I'm simply disposing of giving the liberty to the trial court. You appear, trial court will decide what is to be done. That is the only order, otherwise simple notice. What do you want? You want a simple notice or you want a disposal?
Disposal, my lord.
Let him allowed to appear before the trial court,
Yes,
my lord,
my lord.
because otherwise, my lord, since the NBW has been issued, my lord, so once he will appear, my lord, he will be put behind the bar, my lord.
So I'll say, on appearance, trial court is at liberty to
Grant bail.
consider.
Yes, my lord, that considered part will come, my lord, then trial court will, that is the NBW has already enforced, my lord. Because the trial court will have to, my lord, put him, because, my lord, the NBW, until and unless it is set aside
If
by.
he appears, then we will stay the,
And no, my lord, lordship can do one thing, my lord. Lordship may set aside the NBWA order, my lord,
Yes.
and let him appear before a trial court. My lord. And giving 10 days time, my lord.
heard Mr.
Yes, Islam.
Huh?
Yes, Islam.
S. Islam, learned counsel appearing for the petitioner. Stop. Also heard Mr. R.J. Barwa, learned APP for the state respondent. By way of this application under section 528 of the BNSS 2023, the petitioner is seeking setting aside and quashing and or recalling of the order dated 27/9/2024 passed by the learned session judge Borpeta in session case number 64 of 2020 arising out of Kalgachia PS case number 25/2017, by which a non-bailable warrant of arrest is directed to be issued against the petitioner, fixing the case on 20/11/2024 for appearance, and thereafter with the order dated 12/3/2025, the case is again fixed on 7/5/2025. 7/5 is already over.
Yes, but now we're at 27/6, my lord.
But why, despite 3 times also, you still have not appeared?
No, but
Why?
it's because my lord, because the communication gap of the petitioner and his.
You see, the constitutional courts are not here to, for giving you this. You have been taking advantage. You've been not appearing after the bails. You've been on bail. It is for you to ensure that on every fixed date you go and appear.
Yes, my lord, that is,
Why are you not appearing before the trial court?
that is his fault, my lord.
Orders are there.
Ready to appear, my lord.
Which is the order after 12/3? After 12/3, which is the order? That order is not annexed here.
No, my lord.
Then how do we know? That order, you see, this court,
NBW is continuing.
no, if this court has to stay that order has to be before this court. Isn't it, Mr. Barwa?
My lord, lordship may stay, my lord, that order, my lord, 27/9/2024, my lord.
Yes.
Page number 17, my lord.
12/3/25, 27/9 and 12/3/25.
My lord, 27/9/2024 will do, my lord. Because this is the first that probably one NBW issued, my lord.
The brief facts of the case is that take it from paragraph 3 at page 2.
Order, I would tell you.
Then you write that thereafter the charge sheet was submitted and was submitted on 30/4/2017 under sections 448/376 of IPC. Accordingly, charges was framed under section 417/448/376 IPC against the petitioner and trial commenced. During trial, since the petitioner was arrested, he was subsequently released on bail by order dated 17/4/2020. Don't say that. Say the trial court was also pleased to release the petitioner on bail by order dated 17/4/2020. It appears that subsequently, though it appears that though initially the petitioner was appearing before the trial court on the dates fixed, however, subsequently, because the petitioner did not appear on the dates fixed, the trial court by order dated 27/9/2024. That's the first one, no?
No, my lord, that may not be mentioned, my lord, because before that also he has not appeared, my lord. This was probably the order.
No, but this order which now it appears. The impugned order is of which date?
2009.
57/9/2024. It appears that since the petitioner was not appearing thereafter, the trial court on 27/9/2024 directed to execute court process against the petitioner.
Yes. By issuing NBW. NBW.
Sorry, Mashma, you please delete that part. What did you say last? It appears that subsequently the petitioner stopped appearing before the trial court on the dates fixed, for which the trial court had issued NBWA against the petitioners.
Petitioner.
Against the petitioner along with the co-accused. They were co-accused or against the petitioner. Stop. It further appears that on 27/9/2024, and 2024 and 2011/2024, 21/1/2025 and 12/3/2025. The trial court was further pleased to issue reminder.
And also issue notice to the bailor, my lord.
Was also pleased to issue
Notice to the bailor, my lord.
notice to the bailor. The petitioner. Stop. Where are the grounds?
The grounds of this.
The para 11 notice in peruse, my lord. Page number 6.
Heard and perused. The ground for non-appearance as averred in paragraph 11 of the petition reads as under. Your ground is not convincing. It's not convincing. Your counsel may have died, but you know that a case is going on. What stopped you from coming to the trial court and finding out as regards the next dates?
He said, my lord, next date he will appear, my lord.
Different things. But from 2020, how can you not appear? For 5 years, you have not appeared. Isn't it, Mr. Barua?
Yes.
Or 5 years. You see, the High Court is, you cannot take the High Court for in such manner that you come and this court will give you that protection. You have not appeared for 5 years. Justice has been delayed because of your non-appearance. You were very aware of the fact that a case is pending against you. What stopped you from inquiring? Where are those explanations? What stopped you from inquiring? Simply saying that the engaged counsel died during the COVID period and you could not contact him is not sufficient. That is not sufficient. I'm sorry. You want the dismissal right now? I'm going to dismiss this petition. This can't be.
Answers may be given, my lord.
Sorry, there is no question. 5 years. A justice has been delayed because of you. We don't know what happened. Ultimately, you may not be convicted, but the trial has been delayed
Yes, madam.
because of your non-cooperation. You've taken undue advantage of a bail and you want this court to give you protection now? How can this be? Right, huh? The grounds, reading of the aforesaid grounds, it appears that the only ground urged is that the engaged advocate expired during the devastating COVID, for which reason the petitioner could not contact his engaged counsel, and therefore he could not appear before the trial court for several dates. Stop. The aforesaid ground does not inspire the confidence of this court. It appears that since 2020, the petitioner has not bothered to inquire as to the fate or the next date of the trial which is going on before the trial court. It appears that since the petitioner was on bail, the petitioner did not bother to find out to inquire as regards the next date before the trial court. The petitioner is this court cannot be unmindful of the fact that that the petitioner is facing trial and is on bail. It is the bounden duty of the petitioner to ensure that the trial does not get hampered because of him. That being so, there is no sufficient ground. The petition stands dismissed.
May it please your lordship. This is the application under section 520 ENSS. Lordship may kindly peruse the.
1 second, Mr. Diori. Let me have water. Yes.
The complaint was filed, Lordship may kindly peruse it on page 22.
Page
22.
22.
Complaint was filed.
Criminal petition.
The criminal-
You are challenging the complaint.
No, your lordship. There is an order passed in a miss case. There is an order that has been passed in a miss case. Your lordship, may I just? There was a complaint filed, your lordship, and page 20 is the.
Yes, please.
Your lordship, both the petitioners were convicted. Now, your lordship may kindly peruse page 37, para 20.
Yes.
May I read, your lordship?
Yes, yes.
Taking note of all the facts and circumstances, we are of the considered opinion that end of justice will be meted out if both the accused be sentenced to undergo simple imprisonment for a period of 1 month under section 447 IPC and for a period of 6 months under section 427 IPC. We are also of the view that the complainant needs to be compensated for a damage caused to our property by the accused persons. Accordingly, both the accused are sentenced to undergo SI for a period of 3 months under section 447 IPC and also to undergo SI for 6 months under section 427 IPC. It was also provided the accused shall pay a sum of ₹5,000 each as compensation to the complainant as per provisions of section 373 CRPC, having convicted the accused under section 447 IPC for causing dispossession of the complainant from immovable property by criminal intimidation using force. We are of the view that the possession shall be restored to the complainant after evicting by force, if necessary, the accused in possession of the property. Accordingly, invoking the provisions of section 461 CRPC, it is provided that possession of the land in question shall be restored to the complainant within a period of 1 month from today. Furnish free copy of judgment to the accused immediately. We have filed a revision against that, your lordship, may appeal. Your lordship may kindly peruse page 48 against this order.
So 1 month.
Yes, Your Lordship.
1 month,
Yes,
isn't
Your
it? For both the 447 and 427.
427, Your Lordship, criminal trespass and mischief,
427,
and 447.
447. And for 6 months is in default or what?
Yes, sir, in default.
Yes.
Then 5,000 as fine, Your Lordship, under section 357.
This is the order of the magistrate court,
Magistrate.
trial court.
This is an.
Against CJM, against this,
Appeal, Your Lordship. May I kindly peruse page 37, page 48.
48.
40.
Is there an IA? You have filed an IA?
No, Your Lordship, this was an appeal that we had preferred against the order.
No,
that was
right
posted-
now you have filed a criminal petition,
petition
right?
against an order that's been passed in a missed case. I will come to that, Your Lordship.
Yes, please.
So page 48. Para 10, Your Lordship, may I read?
Yes, please.
Thus, after considering all the matters in its entirety and having regard to the law and facts as stated above, this court is of the view that the learned court below has not committed any error or illegality while holding the view that the accused appellants are guilty of committing offence under section 447, 427, 34 of the IPC. Hence, they are required to be convicted for their offence. The learned trial court, while passing sentence against the accused persons, observed that the accused are young men having the responsibility of looking after their respective families, and they have no antecedent of criminal antecedent. Considering the nature of offences committed by the accused person, by considered opinion is that it will be sufficient to mitigate justice if the accused persons are sentenced to pay a fine only for their offence instead of sending them to prison. In view of the above, the sentence passed against the accused appellant is modified to the extent that they are sentenced to pay a fine of rupees 2,000 by each in default of term of simple 3 months for their offence under section 427-34 of the IPC, while they are sentenced to pay a fine of rupees 300 by each in default of term of simple imprisonment of 15 days for their offence under section 447-34 of the IPC. The amount of fine, if can be realized, shall be paid to the company as compensate for a loss incurred by her due to the offence committed by the accused persons as per the
So
procedure.
sentence have been modified to
Modified.
only fine.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
Now you are against this. Now you have come up with some other miscase.
Yes, Your Lordship. They had filed a miscellaneous case. Your
You
Lordship.
are who? You are the accused.
We are the accused, Your
You're
Lordship.
the accused. Now the complainant filed a miscase.
Yes, Your Lordship.
Yes.
Page 50. This is my order, Your Lordship.
Yes. Yes. They were aggrieved by the fact that you had not been sent to prison.
Yes, Your Lord. They
Huh?
filed a miscase for the repossession of the property, Your Lordship.
Repossession of property.
Property.
Yes.
The fifth line from top, Your Lordship, 1, 2, from bottom, Your Lordship, 1, 2, 3. The line which starts up thereafter.
From the top.
From the top, Your Lordship, from bottom, Your Lordship.
Yes, thereafter due notice.
Yes, Your Lordship.
Due notice.
Due notice. Your
Yes.
Lordship. Thereafter, due notice. Thereafter, due notice was sent to the complainant for receiving the aforesaid amount of compensation, but the complainant by petition dated so and so sought for a direction for restoration of a position of the disputed land as directed by this court by judgment dated 4/6/2010.
4610 is whose judgment?
4/6/2010 is the original order, the first judgment, judgmental order passed by the CJM. Chief Judicial Magistrate.
Under that possession was restored.
No, yes, it was, the order was passed, Your Lordship, but the property was not specified. The schedule of the property was not specified.
Yes, please.
For a direction for restoration of possession of the disputed land as directed by this court, by judgment dated 4/6/2010, again notice was issued to the accused convict to restore the possession of the land, but the accused convict by petition dated so and so submitted objection stating that the aforesaid direction is non-executable as because neither any description of the land has been given nor it was identified. Against that, another application has been filed by the complainant. I had heard learned counsel appearing for both the sides. On a careful consideration and scrutiny of the entire case record, I find that the complaint in her complaint petition did not mention the description of the alleged disputed land. Only a GMC holding number has been given, but the land was not demarcated by giving description of the 4 sides of the said disputed land or any patta or DAG number. The aforesaid GMC holding number does not exist at present as because the complaint itself discloses that the aforesaid house situated on the holding number has already been destroyed. Neither the complainant nor her witnesses ever described the land during their examination before the court. Even in the judgment dated 4/6/2010, there is no mention of the disputed land. Thus, nowhere in the entire case record, neither in the complaint petition nor in the evidence or of the complainant side, there is any mention of the disputed land. Without any description of the land, it is not possible to pass a direction to restore the possession of the said land to the complainant. The aforesaid direction given in the judgment dated 4/6/2010 regarding restoration of the possession of the land is unexecutable order in absence of any such disposition of the alleged disputed land. Now the complainant, by submitting a petition dated 7/12/2011, stated that a description of the land has been given in the proceeding under section 107 CRPC, but the record of the said proceeding was not called for during the trial. of the
This was not allowed.
Not one.
So,
Against that, your lordship, they had filed the page 57, your lordship. A criminal revision was filed, your lordship, by them.
criminal revision
Criminal revision.
before this court.
Before the district and session judge, your lordship,
Yes.
at page 57.
57.
Yes, your lordship.
Yes.
The fifth line from top, your lordship.
In that view.
Yes, sir.
Yes.
In that view of the matter, the impugned order passed by the learned trial court with the observation of the direction given by his predecessor was unexecutable, virtually amounted to reviewing its own order, which is beyond the scope of jurisdiction of a criminal court. When the order has been passed under section 46(1) CRPC for restoration of possession, the order has to be enforced by the court, in as much as there is no scope for a second thought by the same court after the order is made. Rather, it is the onerous duty of the court to enforce its own order. There is also no scope for the accused to challenge such order on the ground of inexecutability before the same court. If the enforcing agency fails to execute the order for any valid reason, that is altogether a different matter. But the court which passed an order under section 456(1) CRPC for restoration of the possession has no jurisdiction.
What kind of an order are you expecting today?
This order, your lordship, the last
So
order-
you want some interim?
Yes, sir.
What
Because
kind
there
of
was-
an
there is
interim?
an order passed by this honorable court where it was very specifically stated that no new schedule of the land will be considered. Unfortunately, the new schedule has been considered and order has been passed by the CGN. Your lordship. Page, then, your lordship, may I,
Yes, please.
page 60,
Let's continue this.
yes, your lordship.
Rather, it is on, there is also no scope. Enforcing agency fails to execute. Page 57,
57,
just complete it.
yes. Sir. Rather, it is the onerous duty of the court to enforce its own order. There is also no scope for the accused to challenge such order on the ground of inexecutivity before the same court. If the enforcing agency fails to execute the order for any valid reason, that is altogether a different matter. But the court which passed an order under section 436(1) CRPC for restoration of the possession has no jurisdiction to review its own order and to say that the order is not enforceable or not executable for want of description or identification of the property in dispute or for any other deficiency in evidence or pleading. It is pertinent to mention that the order passed under subsection 1 of section 456 CRPC would not prejudice the rights and interests of the parties in the immovable property, which can always be established in a civil court. But the criminal court, which once it passed an order under section 456(1) CRPC, cannot review its own order or refuse to enforce its own order on the ground that it is inexecutable because of absence of evidence with regard to identification of land or any other deficiency in the order. In the above view of the matter, the impugned order passed by the London trial court cannot be allowed to hold the field. Against
So
this-
what is the, by this order, which part of this order you're exactly aggrieved?
the order where it is.
Because they have simply said the revision is allowed. Order is set aside,
Yes, Your Lordship.
right?
Yes, Your Lordship.
The order setting aside of the order is that miscellaneous case, whereby it says that no, the order cannot be executed.
Yes, sir.
What is wrong in that?
So Your Lordship may kindly, then they have, thereafter they have filed a miss case, Your Lordship. After this.
After
order-
this
after this
also.
order, they have filed a miss case, Your Lordship, page 63.
It's 63.
Now, page 68, Your Lordship, very important. This is the miss case that they have filed in the original complaint case, miss case number 31M of 2015.
Now, by way of this miscase, they have filed a new schedule.
Schedule, Your Lordship, which in my respectful submission cannot be considered, Your Lordship.
It has to be heard, Mr. Deori.
Yes, Your Lordship.
Right now, it is difficult to give any interim protection.
Notice may be issued, my lord.
Hmm?
Notice may be issued to the opposite.
Notice I will issue, but it is difficult.
The only thing Your Lordship may kindly please order, Your Lordship. Against that, we have filed a criminal petition, Your Lordship.
Yes,
Against the order, in this case, we have filed a criminal
Mr.
petition.
Deori, difficult at this moment. Because the main order is there. That order you have not challenged. All that you're trying to say is that now by way of this miscase, a new schedule has been
Yes, sir.
brought in, but that new schedule is not part of the
Original.
original.
That is why, Your Lordship.
Now, in this criminal revision which you have now filed, in this, are you also challenging the order passed by the revisional court?
No, Your Lordship.
That order is not challenged.
Your Lordship, kindly peruse.
Difficult.
Say page 81 for a moment.
Hurry, Mr.
Page 81
Deori.
for a moment, Your Lordship. Only one.
Not
paragraph.
at this
One
moment.
paragraph, Your Lordship, page 81.
Page
81.
81.
This was passed in criminal petition 923 by this honorable court, Your Lordship.
Yes,
Paragraph 20. In view of all the, Your Lordship got it.
yes.
In view of all the above, the criminal petition filed by the petitioner stands dismissed. However, ISC criminal number 56 or 53 of 2016 is allowed. The learned trial court shall proceed with the miscellaneous case number 31 M 2015 pending before the court without, however, taking into account the new schedule given by the petitioner in the said case. An order was passed, Your Lordship, by this honorable court. Yet, Your Lordship, on 21/5/2025, an order has been passed by the CJM considering the same schedule, Your Lordship. That is why I am before this law. Court, Your Lordship.
This criminal petition is. Mr. Barra, have a look, page 73.
দেখুন দাদা আমি একটু রেজিস্ট্রেশন চ্যালেঞ্জ করেছি কে ওভারটা চ্যালেঞ্জ করুন
This miscellaneous case 31M 2015 is which one? And in that the order has been passed now.
Yes, Your
Show me that order.
in view of the
No,
yeah,
that
page 82 start page 82, Your Lordship, and the relevant portion, Your Lordship, starts at 84.
miscellaneous case 31. Yes.
Relevant portion, page 84. May I read, Your Lordship?
Yes, please.
It appears that by the order dated 19/7/2024, complaint was directed to produce the certified copy of the schedule of the plot of land mentioned in case number 190 M 2008, filed before the then learned executive magistrate Kamrup, and same has been complied with and available with the case record. In the background of the aforesaid facts of the case, the officer in charge of Gorsuk Police Station is directed to take all possible legal steps, measures to ensure that the possession of the land in question, a plot of land measuring 1 katha 10 less situated Lokra Sarani Betkusi on the right side of National Highway 37, while moving from Jalukbai to Beltola, is covered by dock number 1243, patta number Nis Khiras land under Moza Beltola.
Now, how do you say that this is a new schedule?
Because this was never there in the complaint, nor there was any mention in the evidence, Your Lordship. This was only brought in by the miscase. That is why I was referring to the page 60.
All right, then, Mr. Barua. There is already an order of this court.
By humble submission, let a notice be so then let the
Yes.
opposite party appear, my lord.
Let them appear, but till then, because you see, there's an order of this court. The learned trial court shall proceed with the miscellaneous case 31 M 2015 pending before this court, the court, without, however, taking into account the new schedule given by the petitioner in the said case. Now, the prima facie reading of this order, 21 impugned order 21/5/2025 passed in miscellaneous case 31 of 2015 indicates that the new schedule has been looked into. So then, where is the question of not staying it? Yes, heard Mr. T. Deori, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned APP for the state respondent. By way of this petition, the petitioner is seeking is assailing the impugned order dated 21/5/2025 passed in connection with miscellaneous case number 31M/2015 arising out of complaint case number 3388/2008. Stop. Issue notice, returnable 3 weeks. Mr. Barua accepts notice on behalf of the state respondent Extra copies, registered post AD in respect of respondent number 2 within a period of 3 days from today. It appears that Mr. T. Deori, in support of the interim prayer, submits that despite this court in criminal petition 923/2015 and IA criminal 53/2016 in a party namgir pava page 73, in so and so, in the case of so and so, in criminal petition and IA bili kori diba, by judgment and order dated 30/1/2017, while dismissing the criminal petition and allowing the accompanying interlocutory application, directed that the trial court clarified that the trial court shall proceed with the miscellaneous case number 31M/2015 pending before the court, without, however, taking into account the new schedule given by the petitioner in the said case, comma, the trial court by the impugned order dated 21/5/2025 has taken into account the new schedule given by the petitioner. Stop. The impugned order dated 21/5/2025 passed in Miss Case number 31M/2015, operating portion of the, reads as under page 84A to A. A to A, Reading of the aforesaid order, it appears that despite no schedule of land having been provided in the original complaint,
Complaint case number 33388/2008.
in the original complaint, comma, upon being directed by the court the new schedule appears to have been given. However, despite this court having been directed that the new schedule shall not be taken into account, prima facie it appears that the same has been taken into account, which appears to be in contravention of the order passed by this court as stated above. In view of the above, till the return, until the next date, the operation of the order dated 21/5/2025 passed in connection with miscellaneous case number 31M/2015 within bracket arising out of complaint case number 3388C/2008 shall remain suspended.
Very grateful.
List returnable date of this article on a date to be fixed by the registry.
Very grateful.
Item 16.
Yes,
Please, your lordship. My lord,
1 second.
yes.
Yes, washing off.
Quashing of a GR case along with an order by virtue of which the learned court below has accepted a protest petition filed by the informant in the GR case subsequent to submission of final report by the police under section 173 old. Now, my lord, my grounds for quashing before your lordship. Here, my lord, just to brief your lordship with the checkered history of the case, the FIR was lodged by the informant who happens to be the mother-in-law of petitioner number 1 and mother of petitioner number 2, alleging forgery. During the pendency of the FIR, a criminal petition was filed before this honorable court. Notices were issued. Case diary was called for. During the pendency of the criminal petition before this honorable court, the FIR was submitted by the police on the ground of insufficient evidence. Now, after submission of FIR by the police on 27/11/2024, there were a few dates on which, prior to the submission of the FIR, as your lordship is aware, mandate of law requires that notice has to be issued upon the informant, and that was done. The informant did not appear on initial dates. Eventually, the date was fixed by the learned court below on 3/4/2025 for hearing. For hearing, that is the hearing in regards to whether there is any objection or. Now, on 3/4/2025, being aware that the date is fixed, the petitioners, being the accused persons, went to the court only to find out that on that date, the case would not be taken. And they were told that the case would be taken on a subsequent date. But shockingly, down the line, it came to the knowledge of the petitioners that on the very next date, the case was taken up out of turn. And on that date, the protest petition was filed on that very date. And the protest petition was taken note of, and the order that has been passed taking the protest petition into consideration is what your lordship will find that is under challenge here. That your lordship is the
Notice you will get.
my lord. The notice, and my lord, now what has happened is, because of the fact that the learned court below has accepted this protest petition, this protest petition takes the shape of a complaint.
With that, let the other side appear,
Yes, that
Mr.
is- that is
Counsel.
there.
How can this court now give you anything?
Only on law point, what I'm just trying to submit is that this takes the shape of a complaint.
Okay, well, we'll see on the returnable date. I'll keep your interim prayer open. Heard, Mr.
T. Chakravarti.
T, na?
T.
T for Tamil Nadu?
T for the.
Sorry. D. Chakrabarti, Learned Counsel appearing for the petitioner. Stop. State is there? No.
State is there, my lord.
There.
Yes. First.
Also heard Mr. R.J. Barwal, Learned APP for the state respondent. Stop. By way of this application under section 528 of the BNSS 2023, the petitioner is seeking quashing of the GR case number 473 of 2020, registered under section 120B, 420, 468, 471 of IPC 1860, and the order dated 4/4/2025. Passed by the learned SDJM M. Lakhipur, allowing the protest petition being number 19 of 2025. Whereby the police was directed for further investigation and after submission of final report. Stop. Issue notice, returnable date, 3 weeks on such and such date. Mr. Barwa accepts notice on our respondent number 1, extra copies. R2, registered post AD, steps 3 days, list after 3, list on accordingly, yeah? On such and such date. It is needless to be clarified that the interim prayer shall be considered at the returnable date.
Is it returnable or on appearance of the parties, my lord? On appearance of the parties or?
That will be on
after-
appearance of the party. Let it be on appearance of the parties. That will-
Returnable, we'll see,
My lord.
isn't it?
Well,
See, it goes without saying.
Well-
Now, for some reason, if the party is not interested in appearing, then,
then yes, well, obliged, highly obliged.
but it doesn't mean on a returnable date, if service is not complete, your interim shall be taken.
My lord, highly obliged.
Correct, my lord.
Huh?
Correct, correct.
Sorry, Mr. Barwa.
Lordship is absolutely correct. my lord.
Keep clear, keep clear.
I think 17.
Petitioner, before your lordship, the
This is item number 17.
17 lordship.
Mr. Bora, what is this?
The petitioners are employees of APDCL, Lordship. They have challenged.
APDCL?
Yes, Lordship. All the petitioners, there are 5 petitioners. They are permanent employees of APDCL. They have
They are?
challenged, they are employees of APDCL. They have challenged a complaint filed against them, Lordship. The facts, Lordship. Your Lordship, may kindly see page number 23 for a moment. There is an FIR lodged by the petitioner number 1, who is the subdivisional engineer of Bilasipara Electrical Subdivision. He lodged an FIR against the complainant, the opposite party hearing. May I read the FIR, Lordship?
Yes, please.
With reference to the subject cited above, I have the honor to state that today on 27/2024 at about 4 p.m., while one of our disconnection team comprising of our staff, Sri Minazul Haq, Samad Ali Poddar, Abdul Rahim, Asab Ali Mondal, Nisan Ali, Safir Rahman, Shahidul Islam were carrying out their respective duties at Kathaldi Part 1, Golerchar area, where they observed illegal charging of e-rickshaw by means of hooking. While the team was trying to gather videographic evidence of the ongoing theft activity, they were physically assaulted by miscreants named Nishan Ali, son of Usman Ali, Nosia Khatun, wife of Nishan Ali, Jahangir, son of Nishan Ali, Rokibul Islam, son of Nishan Ali, Ayub Ali, son of Asur Sheikh, Ashan Ali, who is the opposite party hearing.
Who is the opposite party?
Asan Ali.
San Ali.
He lodged a complaint later on, Lordship. Son of Asman Ali. During the assault, Samad Ali Poddar and Minazul Haq were severely injured at multiple places. The aforementioned personnel will also received life threats from the alleged. Also, as per the statement, received a cash amount of rupees 82,500, of which 52,500 collection money and rupees 30,000 was snatched from Samad Ali Poddar while he laid on the ground during the assault. This goes beyond way of conduct and requires immediate disciplinary action.
What is that? Also, as per the statement, received a cash amount of
82,500.
which so and so collection money and rupees so and so was snatched from
Samad
Samad Ali.
Who is one of the petitioner before your Lordship?
So he's one of the petitioner.
Yes. Now that case is registered and received that your Lordship will find at page 24, the next page. Received as Bilasipara PS case number 176 of 2024 under section 1172-309 within bracket 4, 132 and 3 within bracket 5 of BNS.
So these officers are
They were discharging
disconnecting team.
disconnection.
Disconnection of the electricity supply.
Yes, that's it.
So while they were doing this, this is what has happened.
No, they were not exactly doing. An FIR is filed because they were physically assaulted by the.
Correct. While they were doing their duty,
Yes.
the incident took place.
Yes.
For which they had lodged an FIR.
FIR.
Correct.
Now your Lordship may kindly see that FIR.
Was registered.
Yes, as registered, and investigation was carried out, and subsequently a charge sheet was filed.
Yes.
In the meantime, Lordship may kindly see.
Charge sheet file also is there, page?
Yes, page number 25.
Charge sheet.
Charge
Yes.
sheet was filed on 28/9/2024
Yes.
under section 1172 and other relevant sections of BNS, along with section 135 and 136 of the Electricity Act.
All right. Now.
Now, in that case, cognizance has been taken against.
And this FIR was filed on which date?
On 27, on the same day, on the
27?
20/07/2024.
Yes. Yes.
After receipt of the charge sheet, Lordship, cognizance was taken by the learned court below.
Yes.
Now, on 24/7/2024, your Lordship will find at page 38. One of the accused person who has been charge sheeted, he filed a complaint before the learned court below, saying that
What is the date of the complaint?
24/7/2024, that is after 4 days of the
24/7/24.
Lordship.
After 4 days.
4 days.
4 days. Yes.
The allegation in the complaint, your Lordship will find at page 40,
Yes.
para number 2, that may I read, Lordship?
Yes.
That the complainant is a poor person who maintained his family pulling e-rickshaw. Since the e-rickshaw running on battery, for charging the battery of e-rickshaw, he got connected electricity by consumer number so and so in his house, and has been paying the electricity bill as per consumed regularly. Para 3, page number 41.
Yes, please.
That since last 3 months, due to his financial hardship, he could not able to pay electricity bill, which falls a year amounting to rupees so and so. That suddenly on 27/2024 at about 4 p.m., the accused persons mentioned above along with 3 unknown miscreants criminally trespassed into the compound of complainant in his absence and demanded an amount of rupees 25,000 from the witness number 1 by giving their identity to be the worker of electricity office. Otherwise, they disconnect the electricity connection of his house. On being refused to pay the demanded, an altercation took place between the accused persons and the wife of the complainant, and that moment, the accused number 1, 3, and 4 used criminal force and tried to disrobe her with intent to outrage her modesty. The other witnesses also came to the PO and tried to solve the matter, but the accused person also gave fist blow to witnesses. At that moment, the accused persons tried to give electric shock to witness number 1, except the accused number 2. The other accused are not the official person so far the knowledge of the complainant is concerned. The accused persons are a kind of day robbers, and by showing their false identity to be the official of electricity office of Bilasipara, extorted various consumer by threatening disconnection, electric connection of their house. The accused person also threatened the complainant and witness number 1 not to make complaint before the authority concerned. Otherwise, they shall suffer dire consequences. Thus, the accused person committed an offense under various sections of BNS.
So this was registered. Cognizance has been
registered.
taken.
Yes, this was registered and a notice was issued to the opposite parties.
You are challenging that now?
Yes, Lordship. The complaint as well as the order dated 24/10/2024.
Why will it come after so long?
Because Lordship, now the SD who was serving at that particular point of time at Bilasipara, he has been transferred to Guwahati, Bijuli Bhavan. Now he is discharging his duties here. So he did not receive the notice. Now, the moment he received the notice here, then he came to know that a case.
Mr. Barwa, it appears that
Absolutely,
an
ma'am.
offshoot of that
Yes, Lordship.
FIR, because if there is any truth, this complaint should have been filed on 20th itself. It has been filed after 4 days.
And in fact,
We have not been made party in this case.
Oh, sorry.
And in fact, if your Lordship peruse page number 36 for a moment, 5 numbers of injury reports are
So
submitted.
here you are challenging 24/10/24 order.
Yes, and as well as the complaint Lordship. 5 injury reports were submitted by the investigating officer along with the charge sheet which was filed by the then SD Bilasipara.
What is the status right now?
It is pending for appearance, Lordship.
Pending for
Appearance.
appearance.
Yes, Lordship. Now, the perusal of the complaint itself shows, Lordship, it's a counterblast to the FIR filed by the SD Bilasipara, when they were discharging their duties. In fact, they were assaulted. And the complainant himself,
Heard Mr. R.
Arbora,
Bora, right? BORA.
BORA.
Bora, Learned Counsel for the petitioner. By way of this petition and by way of this question, by way of this petition under section 528 of the BNSS 2023, the petitioner is assailing the impugned complaint is seeking quashing of the impugned complaint in CR number 1149/2024. Stop. Mr. So-and-so submits that on 27/2024, when the petitioners were doing their duty, when the petitioners being officers of the APDCL Bilasipara
Lordship.
were performing their duties as a disconnection, as being members of a disconnection team, the complainant along with few others were found to have been illegally charging e-rickshaw by means of hooking. and upon trying to stop such theft activities, they were physically assaulted by the complainant and the other co-accused, for which an FIR was lodged on 27/2024. Which after being registered and investigated, charge sheet by the charge sheet number 216 of 2024, dated
28/9.
2024, was submitted under section 117. Sections get to me page 25 of Papa. Thereafter, where is the cognizance?
Page 37, actually.
Thereafter, the jurisdictional magistrate court, by order dated 4/2/2025, upon perusing the case record along with the said charge sheet, took cognizance against the complainant and the other co-accused under section 115, so and so to page 37 of Pajaba, and accordingly issued summons for appearance. It appears that after 4 days of the said incident, the complainant on 24/7/2024 filed a complaint, being complaint case number 1149 of 2024, against the petitioner, along with all the petitioners, against the petitioners, alleging that on 27/2024, they have illegally trespassed into his house and demanded an amount of rupees 25,000 by threatening to disconnect the electricity if the demand is not met. It appears that the jurisdictional magistrate by order dated 24/10/2024 issued notice to the to the petitioners. Stop. Prima facie, it appears that the complaint has been filed after 4 days of the incident and after the petitioners had filed the FIR on the very same day, i.e. 20 so and so. That being so, till the returnable date, the further proceeding
Number 1149.
one second. Issue notice, returnable 3 weeks. Registered post AD and all that. Accordingly, in the interim, till returnable date, further proceedings of CR case number 1149 of 2024 pending against the petitioners in the Court of Learned Judicial Magistrate First Class Bilasi Para shall remain stayed. List accordingly after expiry of the returnable data. Yes.
Item 19.
Please, Your Lordship.
this petition is filed for praying for quashing the entire proceeding of the, my lord, the special P case arising out of the child marriage and POCSO, my lord. Kindly see the FIR, page, my lord, 16.
Page,
Page 16, operative part is page 17. The
Yes.
alleged victim is the
POCSO
wife,
is there.
my lord.
POCSO is there, so notice has to go.
My lord,
Bhargav.
my lord,
See, POCSO
my
is
lord.
there, so notice has to go. Anything else you want to say?
My lord, now the petitioner is the wife of the victim is the wife of the petitioner. They are happily married. Now, at present, she is. married.
Whatever be
My
it,
lord.
notice has to go. Issue notice. Mr. Barwa accepts notice for one. Informant, register post, informant steps in terms of Deepak Nayak. Returnable corridor of 3 weeks.
Can it be fixed before, my lord, 24/7, my lord? The next date is 24/7.
Okay, then the date did you? Returnable on 21st corridor. Yes,
Highly obliged, your lordship.
yes.
May I please, your lordship?
You are seeking quashing of an FIR.
The FIR is of 2020, your lordship.
Yes.
5 years has already lapsed, but no charge sheet has been filed. The informant has also filed an affidavit, your lordship, that your lordship would find it.
You are the informant,
The
accused.
your lordship, but the now, your lordship, the informant.
You mean to say this 2020 FIR is still against it?
Your lordship,
Huh?
but no charge sheet has been filed.
No charges?
No.
All right, you take instruction, Mr. Barwa. Let him first take instruction.
And the informant has also filed an affidavit, your lordship.
Very well, but
That they are not inclined. the
that is all
informant
right.
is
You
also-
will get your relief, but you can't get that on the first day, Miss
Lordship, your lordship.
Counsel.
Can that for an interim, because.
What interim? If there is no charge sheet filed, what interim do you want?
Your lordship,
Call for report. Mr. Barwa, you will please the report?
Manu, we'll call for the report, Manu, whether the investigation is pending or not.
Correct, correct. What is the status and all that? List after 2 weeks, they did on such and such date.
okay.
And issue notice of corridor, register post AD and all that.
21.
Please, lordship.
Yes.
This is for quashing for 145 proceeding, my lord. 145 proceeding pending before executive magistrate. My lord, there are 2 cases, my lord, in similar suit line, my lord. One is
Civil suit is also pending.
pending, my lord. That's why, my lord. Civil case is pending, my lord.
Where is the complaint?
My lord, Annex 1, my lord.
Yes, read.
My lord, page number 9, my lord, type copy.
Huh?
Type copy, my lord, page number 9, translate copy, my lord.
Yes.
As such, I have the honor to say that the petitioner purchased land measuring 1 bika from Mankimura on 19/10/1994 and admit possession of the same. The wife of the complainant, namely Sariful Dutta, was attacked with a kidney problem and she was hospitalized in Brahmputra Diagnostic Hospital on 3/4/2023. Due to absence of the petitioner, the opposite party has constructed a small house on the land on 9/4/2023. That's the case, my lord. Their case is they purchased the land us, and our case is, my lord, we are the owner and position of the land, my lord.
I notice.
Only notice may issue, Manu.
Issue. No, not right now. Let them appear. Interim on the next date. Issue notice, returnable data that is about 3 weeks. Barwa accepts for 1, register post AD for 2, and interim on the next date, returnable date.
Obliged, my lord. Obliged.
Yes,
Procedure
Ms.
lordships.
Devi, your
This is a criminal petition, lordships.
POCSO is there.
We want to stay the FIR as well as the
Rape,
Yes.
sexual intercourse.
No, my lord, that is. lordship
allegation.
kindly- Yeah, no, my lord, the lordship kindly peruse the page 37. 1, 2, 3.
Yes.
On the medical report, lordship got it?
Medical,
Yeah,
at this stage,
victim-
how is the court going to look into the medical, Ms.
My lord,
Counsel?
it is written. the-
Yes,
what it is written there.
first show me where is the FIR,
FIR lordship,
right? As prayed for by Mr.
S.A. Borboya.
S.A. Barbhuya.
Yes.
Learned counsel for the petitioner relist after 3 weeks to enable the petitioner to file the additional affidavit as prayed for.
A date will be fixed, Your Honor.
Welcome. Next.
23.
Keep your Your Lordship.
Yes.
It registered also.
Mr. Bora, this is quashing of FIR and charge sheet.
Charge sheet as well as lordship prosecution sanction order.
Sanction. Where is the FIR?
As per page 21, Lordship.
Yes, please read.
With due respect, it is stated that with the doctrine which I also wanted to place the estimate of
Notice. Issue notice, interim returnable date, and otherwise you're accepting for 1,
My lord.
1 and 2 and 3 register post AD, 3 days after 3 weeks. Yes.
Malad, herein I am challenging, Malad, order passed by the landlord, Malad, in, Malad, maintenance proceeding, Malad.
Maintenance. How much?
Malad, herein I am not commenting, Malad, very specifically on the Malad quantum of compensation, Malad. The fact herein is that, Malad, the petitioner prior to initiation of this proceeding under 125, Malad, he has filed in domestic violence case. And that this honorable court in the domestic violence case, Malad, that as a monetary relief, 3,000 has been awarded. 3,000, my lord. In that, DB case, my lord will find on page 61, my lord.
All right, notice.
My lord,
RJ Barwa 1, number 2 is
All the respect,
registered post AD.
with all the respect, just for a minute, my lord. With all the respect, my lord.
Yes, yes.
Very quickly, my lord, hearing my lord, ground of challenge is that, my lord is very much awarded after my lord coming into existence of this, my lord, Rajnath, my lord, and.
I'm not being able to hear you properly. I think the fan kikhonor karone niki bor digdar hoy. Yes.
My lord is getting, my lord. So, my lord, after the coming into that, my lord. After this, my lord, the honorable, my lord, apex court judgment, my lord, my lord, of this, my lord, Rajnath Neha, my lord, my lord, a guideline has been formulated. And my lord, there is a specific direction mandatory that is as per the observation given in that particular case.
Assets and all that.
My lord, my lord, my lord. That
Not,
has
not
not
at
been,
this stage, Mr. Counsel.
my lord, that has not been submitted, my lord.
All right.
Just for a moment.
I'm keeping your interim open. You want me to reject it right now?
No, my lord. Only
Then
I'm
I'm
saying, my
keeping
lord,
it
till
open.
returnable
Issue
date.
notice.
Till returnable date, my lord. Till returnable
No,
date.
no,
Because,
no.
my lord, there is.
3,000, admittedly your wife, no?
No, my lord. Admittedly, no, not my wife. There is some other disputes are there so far. So far the marriage is concerned. That will, my lord, that contention I will raise in hearing, my lord. Only, my lord, the marriage is
All right.
there. My lord, just for a moment, it is a discussion of your lordship. I am not bottling your lordship, my lord.
And interim to be considered the returnable date and Barwa 1 or 2 registered post AD. At that date did your
6,000 has been, my lord, paying.
All right.
My lord, marriage has been substantiated only on
Next.
my lord, APDCL, my lord. Fine.
Sorry, Mr. Counsel.
My lord,
Next.
my lord, APDCL, my lord, for disclosure of their assets has not been filed by neither of the parties.
Very well. Next date.
My lord.
Next.
My lord. 6 of like.
Yes, Mr. Chaudhary.
My lord, in this case, my lord, we are challenging the validity of an order that your lordship will find at page 31 to 33.
Hey, Rupak, এইখন বন্ধ কৰা এই সাউন্ডটো বেছি জোৰছে আহি আছে ক'ৰ পৰা আহি আছে কিহৰ হয় এইটো কি মেচিন call someone because it's very difficult. I think এইখন এবাৰ বন্ধ কৰি চাওকচোন Is it all right if the fan is switched off? Yes,
May I please, my lord, in this case, we are challenging a validity and order dated 4/6/25, my lord. In this case, what happened is that, my lord, the complainant, that is the respondent, file a case under section 138 of the NI Act against me, alleging that he has supplied wood.
he has supplied
wood
to,
to me, so to me, and I have issued checks, which those checks get dishonored. So, my lord, the case was posted for cross-examination, and we have we started cross-examining the, my lord, the complainant. My lord, the cross-examination part will lordship will find it page 17, my lord. I'm just reading, my lord, why it is relevant.
no, what is that you are challenging here?
Here, my lord, the learned court has passed an order saying that I cannot do cross-examination of the complainant beyond my defense plea.
Where is that order? That order is under challenge.
Yes, my lord.
Where is it?
Page number 31 to 33, my lord.
Page number?
31 to 33, relevant portion, lordship 33.
Page number 30,
31 to 33.
31, 33.
31 to 33.
Yes, much better now. 31, 30. Yes.
My lord, I'll read. Today is the date fixed for hearing cross-examination of PW. I have heard the learned counsel of the accused on the point of cross-examination beyond defense plea of the accused on so-and-so date, which is reflected in the order that so-and-so. Today I have had the learned counsel for the complainant on the point of cross-examination beyond defense plea of the accused. The learned counsel for the complainant submitted it in the written defense plea, which was submitted by the accused by petition number so-and-so. The accused admitted the fact of giving checks to the complainant and the fact of supplying wood by the complainant to the accused. The only defense of the accused took was that the checks were given to the complainant's security deposit. Now the accused cannot take the plea of defense in cross-examination of the prosecution witness that he did not give the check. Learned counsel also cited judgment, that is meters instruments private versus concern matter reported in AIR 2017 SC 492, which was earlier cited by the learned counsel representing the accused. We have also cited the same judgment. Citing the same, the learned counsel for a complainant pointed out that paragraph 21 of the judgment, where Honorable Supreme Court observed that the accused who wants to contest the case must be required to.
What kind of an order is this? How can he not be allowed to cross-examine? Mr. Barua, are you there in this case or you're not?
Relevant last portion, my lord, last paragraph.
Owing to the facts.
Owing to the fact and submission, I deem it fit to allow the parties to cross-examine the matters
Relevant to the instant case.
But the accused is directed not to take a plea during
How
cross-examination.
can he not take a plea during cross-examination?
Yes, madam.
He is open to cross-examination, whatever he wants.
Yes, madam.
Isn't it, Mr. Barua? That is the law.
Even, my lord,
For cross-examination, can you be restricted now?
No, my lord.
He's taken a plea. That is the only chance for the accused.
Yes, my lord, cross-examine anything, my lord.
Correct.
Essentially, my lord, the subject matter of the case, no.
That's right. Here he's trying to make a foundation of his defense that he has only issued the checks for security deposit. Now he's putting some question in that regard. How can he be told that you cannot make this now and you have to take this plea in the written objections? Cross-examination, he can take a plea. Tomorrow the trial court may not consider. That is something else, isn't it?
Absolutely correct.
But the problem is this matter cannot be disposed of without
No, yes, my lord.
Opposite party.
without the opposite party.
Let them appear, my lord. Till then, my next date is fixed on.
But how can I state?
My next date is fixed for 27/6 for cross-examination. So if we go
They
there,
can
my
take
lord.
time, my lord. In cross-examination, they can take time. my
No,
lord.
no, if cross-examination, date has gone, my lord. So 27/6 is the date for cross-examination. So if we go there, my lord, we won't be able to cross-examine him. My lord, may I see the cross-examination?
How many witnesses are there, Mr.
My lord,
Chaudhary?
witness till that they have given the evidence of only one witness, that is the complainant. my lord.
How many are there?
Now, till that they have not submitted any other witness. After the maybe after the cross-examination is over, they may apply, my lord, for filing other evidence, my lord. But here, my lord, the cross-examination, we have taken some plea, my lord, that what was the measurement of the wood that was delivered, whether there was transit pass. So.
No, you see, Mr. Chaudhary, this court is not going to stay the further proceedings for this reason. This is not be right.
But otherwise, my on 27, if you go.
When is the next date?
On 27/6/2025.
27 July.
This month, 27/6.
Or this 27.
Saturday.
Why don't, let's do one thing, let's fix it on Friday ki tarikh. 27. Aji hole 24. 7 is the next date.
So, one thing,
You hear the order and then you tell me what you want to say. Heard Mr. I Chaudhary, right? Learned counsel for the petitioner. By way of this petition, under section 528 of the BNSS 2023, the petitioner is challenging the order dated 4/6/2025 passed by the Judicial Magistrate First Class Tinsukia in NI case number 151 of 2023. Issue notice, returnable Bondho Khular Dina Divyo on such and such date. Steps it appears, considering that the challenge made in this criminal petition is the restriction put by the trial court on the cross-examination of the complainant stroke respondent by the petitioner, comma, in view of the fact that further cross-examination of the complainant is fixed on 27/6/2025, this court deems appropriate to to give liberty to the petitioner to serve the copy of the copy of this instant petition to the learned counsel appearing on behalf of the complainant on the next date fixed before the trial court. And full stop. List this matter on such and such date, on which date the interim, on which date interim relief sought for shall be considered, and or an endeavor shall be made to dispose of the criminal petition. Stop. Since the matter is fixed on so and so date, by giving liberty on so and so date, comma, in the event the petitioner serves a copy of the petition before to the complainant on the next date fixed before the trial court, comma, the trial court shall accommodate the petitioner for adjourn the cross-examination to another post 20 reopening date post such and such date. Anything?
We may be served to complainant as well as the counsel for the complainant.
Okay. Mr. Chaudhary, ask your junior to be around. Once the draft is ready, just have a look at it.
Yes.
Because what is important is that you
Yes, yes.
give it to, it should be served. Otherwise,
Yes.
okay, to me, to the learned counsel and or to the complainant. Okay.
Obliged.
You file on that date, you file an affidavit. Yes.
27.
Yes.
Please, your lordship.
Yes, Mr. Chaudhary.
Lordship, in this case, lordship, the petition, I filed this case for quashing of the FIR.
Allegations are very, very strong.
Lordship may peruse the order dated 26/5/2025.
Huh?
Order dated Page 23, Lordship.
Page
Page 23, Lordship.
23.
He was in custody for 29 days, Lordship, and thereafter he filed bail application. And after perusing the case diary, Lordship, this honorable
That's
court-
right. He is rightly given bail.
Lordship,
So now you want to quash
Lordship,
the FIR.
Lordship.
Notice. Notice. Mr. Barua, except for one registered post AD, two, list on such and such date.
If you will.
Yeah, about 3 weeks, man.
3 weeks.
If you will.
28. 28.
Yes, Mr. Goswami. Charge sheet and criminal proceedings.
My lord.
376 is there.
Oh, no, it's not there, my lord. That is why we have come, my lord.
It's not there. Of course,
Your lordship will
you will
come to the charge sheet.
you will know it is there or not there, but this court will have to take it on the face value of the allegation. So all that this court is concerned is whether on on the face value, whether on the face of the FIR it is there or not.
My job is to, my lord, establish that it is not there. my lord.
Correct. So
For that
let's see the
purpose,
ingredients, whether it's
your
there or
lordship
not.
will kindly come to page 22.
Page
22, my lord,
22.
which is a charge sheet.
Yes.
It's a very short, my lord. I'm
Yes, yes,
reading-
yes. Please read, please read.
The brief fact of the charge sheet is that on so and so, the informant by written information informed that at about 10:30 AM in the morning, when the husband of the informant was not at home, the accused Krishnakanta Borua, son of Sri Bipin Borua, a resident of Lakhini Gaon, with ill intention entered into the house and attempted to outrage the modesty of the informant against her will. And accordingly, a case was registered and investigation was carried out. During investigation, the place of occurrence was visited and sketch map was prepared there. The clothes and pen drive, your lordship will note, this is the CCTV footage. Were seized during investigation and brought to the notice of the Honorable Court, which recorded as seen. So these are the part of the records before the court below. Now, having found sufficient material evidences while investigating into the offence against the accused Krishnakanto Borua, he was arrested and forwarded to the Honorable Court since he has been on bail, madam. During investigation, statement of the victim was recorded before the court and victim was medically examined. This is important, madam. And collected the medical report, and after going through the medical report, it is seen in the opinion of the doctor that doctor has not identified any sign of sexual assault. Although the case was registered under section 447-376-511 IPC, but after recording statement of victim during investigation, the case was found established under section 447-376-354-511 IPC. Charge sheet is laid before the Honorable Court under aforesaid section so and so, so and so, so and so. Now, well, this is the case, my lord. So 376 goes by. The medical report says it is only her statement, but her statement also will have to be, my lord, taken together with the allegations made in the FIR. You also will kindly come to the annexer 1.
So charges was the charge sheet was submitted under 376 as well.
376, it was registered, my lord. Then
No, but this annexure 3 is the charge sheet, isn't it?
Is it a charge sheet?
Charge sheet.
I've given the one in vernacular also.
See, Mr. Goswami, at this stage, how do you expect the court to look into all this? It's a matter of trial. In fact, this court in so many decisions, this court also has given a judgment that medical court is immaterial when it comes to the sole testimony if it inspires the confidence of the court. And right now the matter is investigated. Allegation prima facie is there. Where is the FIR?
That is what, my lord. The charge sheet is a culmination of the investigation.
Let us see the FIR.
Yes, madam. Page 13, madam.
1-3.
First of all, 376 is not a case of the informant.
Let's see 13.
Page 13, madam.
Yes.
As your lordship got it.
Yes.
Humble submission is that the accused person is brother-in-law. My husband is in service in BSF. Today morning at about, my lord, her husband and the accused, they are cousins, my husband is in service in BSF. today morning at about 10:30 AM, the accused person with bad intention came to a house in absence of my husband and entered in my bedroom, forcefully tried to establish physical relation with me against my.
It is there.
No, man, no, and outraged my modesty by.
Yes, it's
disturbing my-
there.
At that time, I could save myself by shouting.
Yes. Attempt is there.
376 is not there. 376.
And now
not there.
statement.
My lord,
Statement.
but statement 376,
Where is the statement? Is the statement annexed here?
no, that 164 is there, my lord, it is not given to us. Your lordship.
You have
my lord,
Record
scan
may be
copy.
called from.
records. Sorry,
Scan copy.
let's call for scan copy of the
My lord, that will be my lord,
My lord, now it-
PRC case number, my lord, 369/2024, man.
scan copy of the PRC case number 369 of 2024 pending before the Chief Judicial Magistrate Lakhimpur, North Lakhimpur, arising out of FIR dated 24/1/2024, registered as North Lakhimpur PS case number 16/2024 under section 447, 376, 511 IPC. Notice Korea Diba. Borwa accepts for 1, our registered post AD for 2, are on top BD Goswami and Borwa. And at a date didyog after 3 weeks. Interim to be considered after receipt of the scanned copy of the case records.
My lord, can you have a date before 22nd, my lord, because 22nd is an exit fixed. July.
22nd of
18,
July.
18, can it be 18?
July.
And-
Didyog.
18th. Much of it.
29.
Yes, Mr. Biswas. NDPS.
Yes, but I've challenged the charge sheet. What happened? In the charge sheet specifically, there is nothing. Only that there the co-accused said that they have come to deliver the goods to me. Then, my lord, I was arrested on 30.
What is the allegation against you?
That these two persons from whose position the alleged heroine were found, they said that on intervention that we have come here to sell it to this to me.
Petitioner.
Yes.
They've come to sell to the petitioner.
Yes, but I do not know them.
How can we quash this?
My lord, that's why my limited prayer at this stage, kindly call for the scan copy of the entire evidence, and my lord, thereafter a lawsuit will decide.
The answer may be called from.
Uh,
Can give the answer, man.
Notice Korydiak. Barwa 1, registered post AD 2, scan copy of the case records.
Of my lord, GR case number such.
No, NDPS case.
Yes.
Of NDPS case number 109/24,
Minor.
corresponding GR case number 679/2024, and Sonai PS case number 32/24 under page 2, cost item.
Pending before additional session judge. So,
I've told you.
future.
He'll write.
But date may be fixed. my lord. After vacation.
21st, Mr. Biswas.
April.
Item number 54.
Yes, Mr. Gautam, this is that case.
Yes.
If
Yes.
impleaded.
Yes, ma'am. The production list, ma'am. Item number 2. IA 688.
So I had to some.
The learned prosecutor.
And the IA first at Lekha. Heard Mr. A. Gautam, learned counsel for the applicant. Stop. Also heard Mr. R.J. Borwa, learned AP. APP is there or not? APP for the state respondent. By way of this application, the applicant is seeking impleadment of Shri Manoj Mohanta, stroke informant, as party respondent number 2 in the accompanying criminal petition number 697 of 2025. Stop. It appears that the accused, the informant was inadvertently not arrayed as a party respondent while filing the accompanying criminal petition, and accordingly the instant application has been filed. In the interest of justice, the application stands allowed. Accordingly, Mr. Shri so-and-so is included as respondent number 2 in criminal petition number 697/2025. Top. Let an amended cost title be submitted. You have prepared the amended cost title. Have you this to dispose of? Where is it? You have it with you. Be submitted before the registry within the course of the day and disposed of. In the criminal petition, now you read. Yes, what was the, where is the FIR?
Page 39.
Page?
39.
39.
The narration is at page 42. The FIR begins at page 49.
Page?
39. The
No,
narration,
narration is at
page 42.
42. Yes.
Let me read.
Yes.
I, Mr. Manoj Mohanto, along with my wife, Srimati so-and-so, met so-and-so proprietor of prime property and realtors located at so-and-so in mid of 2019 in connection with purchase of one property at Guwahati as we were searching for a residential flat therein. Accordingly, she introduced us to one Ashok Verma and Saroj Verma, which are the petition aspirants of so-and-so, who according to Lalita Jain intends to sell their property being so-and-so located at so-and-so. As such, believing them to be genuine and finding the property to be suited to our demand, we agreed to purchase the property at rupees 68 lakhs, out of which rupees 13,60,000 was to be paid to them in advance before execution of agreement to sell, as well as an amount of rupees 27,000 towards obtaining of sale permission in cash. Accordingly, as suggested by Lalita Jain and as demanded by Ashok Verma as well as Saroj Verma, we made a payment of rupees 13,60,000 through online mode to Ashok Verma as well as Saroj Verma in the month of November and December 2019. And thereafter, agreement for sale was executed between us on 11/1/2020 at Guwahati, which has been duly registered before the so-and-so. Copy enclosed herewith for review. Be it stated that as per the terms of the said agreement, Ashok Verma as well as Saroj Verma immediately on receipt of the amount of rupees 13,60,000 and on execution of the agreement for sale were to furnish all the requisite documents pertaining to subject property to us, thereby enabling us to avail loan towards the said property. This I'll come back to minutes. Sir, as such, after this last part that I've read, I'll come back to minutes. This is one of my submissions before this honorable court. This is absolutely false. Sir, as such, after
only problem is the Gautam, this court at this stage is not going to go into what is false and what is not false.
It's absolutely on the
only thing I am right now seeing is that whether it's a purely civil case or it's a case where both civil and criminal is attracted. That is the only thing I'm seeing. If you can convince me on the basis of the FI on the face of it that it is purely civil, you will get an interim. If you don't have a purely civil, then you're not getting an interim. Right now, I'm making it very clear to you. Isn't it, Mr. Barua? That is the law.
Absolutely.
Yes.
Absolutely.
Read.
Sir, as such, after execution of the agreement for sale and after payment of the said amount, we approached Ashok Verma as well as Saroj Verma for the documents. However, on one or the other pretext, they started avoiding us and started to make time on false pretexts. And finding no way out repeatedly, we approached them, but in vain. Subsequently, all of a sudden, in the month of October 2020, Ashok Verma as well as Saroj Verma demanded another 1 lakh from us towards society maintenance and stated that if we fail to pay the same as per their demand, they will not provide the document and will go for cancellation of above stated agreement for sale. As such, finding it fishy, we agreed to go for cancellation of agreement for sale dated 11/1/2020. My lords will kindly take them. However, as per the terms of the agreement, we asked them to return the amount of rupees 13,60,000 along with the interest at 12% per annum, as well as amount of rupees 27,000 paid by us towards obtaining sale permission, to which they stoutly denied. Finding no way out, we agreed to accept the amount of rupees 13,60,000 and 27,000, excluding the interest part. However, even after this, Ashok Verma as well as Saroj Verma is showing no interest in and accordingly, when we approached Lalita Jain, proprietor of prime property and realtors, she stoutly denied to interfere in the matter, stating that she had nothing to do with the sale. Sir, of late, Ashok Verma as well as Saroj Verma had categorically made it clear that unless and until they manage to sell off their property being so-and-so located in so-and-so, they will return the amount of so-and-so to us. And when we objected to that, they rebuked and threatened us. Now, this is the FIR. Now, my lords will kindly see the tone and tenor of this FIR is that they want the money now. They filed a suit for specific performance of this contract, my lords. Their case in the FIR is that we have cancelled the contract. Their case in the suit is that we are always ready and willing to perform the contract.
Karwa, I think on the face of it, it seems to be a purely civil.
My lord,
What
my
is the
promotion-
criminal
my
criminality?
promotion, my lord, it is not, my lord, because, my lord, a bare provisional of the FIR, my lord, Lordship will sign, my lord. See, my lord.
What is the
There are
criminality?
allegations
What is the
because-
criminal offense?
Because, my lord, the execution.
No, what is the criminal offense?
Criminal offense, my lord, Lordship may kindly come to page number 50, my lord.
This is registered
Yes.
under sections
Charges have been framed, 406 and 506.
406 criminal breach of trust,
Breach of trust and
And?
506 criminal intimidation.
506
6.
is criminal intimidation. For criminal breach of trust, first of all, there has to be an entrustment.
Exactly.
Now,
Lordship may kindly come to page number 50, my lord. Paragraph 12, my lord.
yes,
Page number 50, my lord.
yes,
May I read, my lord?
yes.
That at any point of time, the purchaser cancel this agreement and or not willing to purchase the scheduled property, then the first party shall refund the advance amount after deducting 12% interest per annum.
Term of the, hold on, this
Question
is
is
the
that,
term
my
of the contract.
Question is that, my lord, then.
Anyway, at 2. In the meantime, yes. I think there is one VC. Yes.
Your Lordship,
Yes.
yes, this is bail application under section 483 BNSS, read with section 37 of NDNPS Act. Yeah, and this bail application is listed for the first time, and if notice may be issued to the respondent.
Who is there for the APP?
Yes, Your Lordship, I'm here. Vane Isyame.
So when do you want it?
This week, Thursday or Friday.
Yes, Miss Vanswami.
No, my lord, I have no objection.
Thursday or Friday?
If the matter may be listed on Friday, Your Lordship, Friday.
Vanswami, her name. All right. Heard, Mr.
LS Laram Chuana.
So and so learned counsel for the bail applicant. Applicant stop. Also heard MS so and so learned APP for the state of Mizoram. Issue notice. So and so accepts notice on behalf of the state respondent. List on such and such date. All right. Friday.
Friday.
Item number 54.
My lords.
Yes.
I was submitting, my lord. Yes, sir. My lord, Lordship may kindly take it.
Mr. Counsel, you have given the amended cost title.
There's a small correction. We had made all the corrections. There's a small correction, para 2, in Lordship's petition that has to be written.
Huh?
Because in the amended cost title,
you need to.
Para 2 has to be written here. So I'll do it by the end of the day today.
Then I'm having it tomorrow. Make the correction.
It's corrected only, minutes. Here we can make the correction by hand only.
No hand. Tomorrow. As a first item.
Tomorrow at 2 p.m. my lord. First hour, my lord, I've got some difficulty, my lord.
You want it at 2 o'clock?
2 o'clock, my lord.
Tomorrow at 2 then. You please do whatever is to be done.
Yes.
Because I had actually called for the section person, so I thought that by the time if I have to give an order,
Was done.
the name.
Louis Millards,
So
that
you do one thing, you immediately retype whatever is to be done and give it to the court master before the day ends, so that the changes can be made. I have already signed the other order, so
if
it can be
Millards will take it
immediately
up
done
in 1 hour, Millards, I'll do it.
tomorrow.
Tomorrow. Sorry.
Release tomorrow.
Fix that.
The fixed item as an fixed at 2, huh?
Grateful.
Qualification, item number 31.
The future lordship, senior is late. Lex lordship, Mr. Mandan sir is.
This
late.
is our admission.
Yes, lordship.
31.
Yes, lordship. Another matter may be fixed, lordship.
But okay, then Thursday.
No, lordship, matter may be passed over for time being.
All right. You have a IA.
Lordship.
What is the urgency? You have an IA.
Yes, I allowed.
Because it's an admission matter.
Lordship, senior is coming.
That I have understood, your senior is on legs, but what is the urgency today? The matter is for admission. I can admit it.
10 years conviction. 10 years conviction and 376.
I think there is an IA.
IA.
Probably. Anyway, time being. The problem is when juniors make a mention and they don't even know what is there. Simply because the senior says that I'm on leg doesn't mean you come and make a prayer. You must be knowing what is the urgency and why the matter needs to be fixed at as a time being. Yes, next.
32.
The criminal appeal.
Our judgment and order dated, my lord.
You have a IA.
Yes, ma'am. Yes, ma'am. Suspend of sentence.
What is the sentence?
Sentence, my lord, 1 month.
1 month?
No, means 1 month for section 341. And my lord, 6 months for section 324. 324 IPC.
Were you on bail during your?
Yes, during the trial, I was all along the bail.
And during, okay.
He was in previous bail. Yes, previous.
You want to go on previous bail? Where is the I?
I am.
In the criminal appeal, you write admit, call for case records, notice.
Notice should go.
Notice. No, it's an admit, no? And steps.
That's number.
Then you say Mr. MP Goswami. DP Goswami, let APP accepts notice on behalf of R1. Steps by registered post in respect of respondent number 2. List after so and so. And in the IA, heard Mr.
D. Gogoi.
D. Gogoi, learned counsel appearing for the applicant. Stop. Also heard Mr. DP Goswami, learned APP for the state respondent. By way of this application under section 430 of BNSS 2023, the applicant is seeking suspension of execution of the impugned judgment and order dated 29/4/2025, passed by the learned session judge Sipsagar in session case number 147 within bracket SS/2022, whereby the applicant was convicted under section 341 IPC and sentenced for 1 month simple imprisonment and to pay a fine of ₹500, ID, simple imprisonment for 15 days, and under section 324 IPC, RI for 6 months, fine 500, in default, simple imprisonment for 15 days. Just reframe the sentences. I give you a short. The brief facts of the case is that the applicant has been prosecuted and convicted in session case number 147 SS 2022 on 29/4/2025 by the learned session judge Sipsagar and sentenced thereof. Accordingly, the accompanying criminal appeal has been preferred. The instant application has been filed for suspension, the execution of the aforesaid conviction and sentence, and for allowing the petitioner to remain on previous bail. Heard, perused. The grounds in support of the prayer made in this application reads as under. Paragraph 3, 4, 5, 6. Reading of the aforesaid paragraph, it appears that there are substantial grounds urged in this appeal, in the appeal. It further appears that the petitioner has not taken any undue advantage during trial while was on bail. In view of the above, the petitioner is allowed to remain on previous bail in connection with the session case number 147 SS/2022 pending disposal of the instant appeal. Stop. Further, the operation of the judgment and order dated 29/4/2025 passed by the learned sessions Judge Sipsagar in session case number 147 SS/2022 shall remain suspended pending adjudication of the instant appeal. Disposed of. $33.
May please do your check.
IA is there.
IA is there. That is
Yes.
659 of 2025. IA is there, my lord.
How many?
Sentence, my lord. 4 years rigorous imprisonment under section 363 IPC at
363 IPC. 366.
66.
No. 363.
363.
Yes, yes.
And POXO 6 is there also.
He is not acquitted of the, he is acquitted of the POXO.
No.
There, my lord. But he is acquitted of what the 366 as well as section 4 of the POXO. His
We
conviction.
cannot understand anything that you are submitting.
Yes, yes. Lots of kindly page 43 may kindly be seen. Page 43 of my memo of AP.
Mr. Goswami, what is the offense under which he has been convicted?
Yes, conviction 363 of IPC.
366?
363. 363.
353.
363 of IPC under
363,
for 4
yes.
years.
Yes.
And
At the same time, he is acquitted.
and
At the
for
no.
POXO is not there.
It's not there.
And at the same time, he is acquitted of such under section 3.
This criminal appeal has come up for the first time, isn't it?
First time.
Criminal appeal, and it's a otherwise main case POXO was there.
POXO was there, but
Allegation was there, not convicted.
not convicted on POXO.
Now, informant is a party.
Yes.
Yes, Lord.
All right, I am issuing notice. In the appeal, you say admit, call for case records, steps, Mr. Goswami, except for one, for two steps in respect of two in terms of Deepak Nayak, huh? And list so and so after the returnable date. And in the IA, also issue notice. Similarly, in the IA also issue notice and give it listed on such and such date. Yes, next. Call Mr. Manan's matter. He's here.
Let's say, we are seeking suspension.
Let the notice be served first. Notice, you should notice both in I. also.
Convicted and.
Yes, next.
Like.
And Manano at a matter of signature, put going.
31. Okay. Can be either 31.
Also, this is a appeal against conviction of 10 years, your lordship, under section.
10 years.
376. Lordship, statutory appeal, your lordship may admit this.
Yes,
There is
and
a-
issue notice in
Yes,
the other one.
And the IA, your lordship may issue notice because the
All right.
complainant is also there.
In the appeal, you write, admit and call for records from the trial court.
From the additional session judge FTC Rongya Kamrup.
Additional Session Judge, FTC,
Rongya.
Kamrup.
In sessions case number 57 of 2018.
In session case number 57 of 2018. And Mr. Goswami accepts notice on behalf of one, extra copies, two registered post AD within 3 days, and in the IA, it will list after so and so. I also similarly, you issue notice, the same thing, okay? You want a date?
To your lordship.
3
After the
weeks.
vacations.
3 weeks.
3 weeks. Much obliged.
Item 34.
Yes.
Lordship, it is appeal against acquittal, lordship.
Appeal against
Acquittal, lordship.
acquittal.
Yes, lordship.
Okay.
Judgment and order dated.
All right, admit.
Make a notice that.
That's territory appeal. Admit. Mr. Goswami for one, registered post AD for respondent number 2, case call for case records from
Session judge, lordship, Kamrup Metro. Distinguished session judge.
from the Court of Session Judge Kamrup M. Guwahati, Assam, in session case number 24 of 2013. And list after 3 weeks I have given. So then returnable 3 weeks and leave it after 3 weeks for a date to be fixed by the registry. All right.
35.
35, yes. Appeal against?
APL is the
Appeal against?
against the order dated.
Conviction or acquittal?
Conviction, my lord.
Conviction.
Yes.
Okay, admit. Call for case records from the Court of Special Judge Jorhat in special NDPS case number 2 of 2023. Mr.
And Pandit.
Goswami accepts notice for one, extra copies, list, returnable date. Huh? Yes, next. 3 weeks.
36.
Conviction or acquittal?
Conviction.
Conviction. Admit. Call for records from the Court of Court of Special Judge Sirang at Kazolgaon in special case number 29/2024.
Issue notice 10 of.
Mr. So-and-so accepts notice for one, and in respect of two, in terms of Deepak Nayak, 3 weeks.
August, November 27.
This is an application,
Yes.
your lordship, for condonation of delay.
Delay?
Yes, there is a delay. Earlier notice
Anyone,
have been issued.
notice issued?
Issued, your lordship.
Yes, who is
It
there?
issued.
How many days, Mr.
The
Mannan?
delay, your lordship, is of 929 days.
921.
929.
Into 9 for filing the accompanying appeal.
Appeal, your lordship. And here I have.
What was the conviction?
The conviction is there, your lordship. The conviction is for 3 years.
3 years.
3 years. And
What
your
is the
lordship-
ground for delay?
Ground for delay I have given your lordship. Basically,
In
the main
nutshell?
ground was he was, after the conviction, actually, this was 3 years. So he was not in jail at that point of time.
Thereafter, he was in medical issue and
He was in?
he was under medical treatment for a very long period of time. And that period, your lordship, he could not. Later on, when your lordship, he did not come for an appeal because it was a appellate provision is there because 3 years. Then he was arrested. After that, your lordship, his family members have come and then they have come for this. So in this period, and your lordship, I'll just
yes, Mr.
One just small judgment. This is
Yes.
POCSO 8 is there, so
Yes, but it's a statutory appeal. There has been a delay. Yes, write down. Heard Mr. Y.S. Manan, it's a POCSO, but somebody is there or not? Informant notice has been issued.
Notice have been issued, your lordship.
What happened to the notice? Unserved notice has been received by the concerned section with addressee moved, so return to sender. But this notice should have been gone through the jurisdictional police station if POCSO is there, isn't it? As per Deepak Nair.
That's it.
Mr. Manan, you had taken registered post notice. But if I'm not wrong, it has to be done.
Actually, at that point of time, the direction was to issue notice.
This is of 24. By then, I think Deepak Naik has already come. Isn't it?
Yes.
If I'm not wrong, because the direction in Deepak Naik is prior to my elevation. That much I know, because I happen to be the amicus in that case.
Now the question is whether there was no direction. So I think it was taken by registered post.
That is why.
This is a
So let
continuation
me,
part.
the only thing difficulty is because of that.
Yes.
Otherwise, I was ready to condone it. But that is the only
In
difficulty.
fact, the recent decision has also come from the Honorable Supreme Court. I would have produced that, but
This is on a different.
on a different.
Without looking into that decision of yours, I was ready to condone it, Mr. Manan. Now, because of that decision and fact that POCSO is there, perhaps
Yes, in
that
that case.
notice
your
needs
lordship-
to be.
Yes, may direct that. We can.
It appears that the connecting criminal appeal, accompanying criminal appeal arises out of the offense under the POCSO Act so and so. However, the notice issued to the informant, earlier was through the registered post AD, which has also returned back as unserved. Be that as it may, let fresh steps in view of the direction passed in so and so be taken. You have a look at that Deepak Naik's judgment. There is an office memorandum. So as per that office memorandum, now you take the steps. A list after 2 weeks on a date to be fixed by the registry.
Lots.
38.
Ma'am, please. There is IAS pending lordship and earlier was rejected lordship.
Earlier I was rejected.
Huh?
Earlier I was rejected, lordship. So
Rejected.
Earlier
This
rejected.
is a second IA.
denial.
Second IA for how a second IA is maintainable? Huh?
There is no bar lordship that can.
Huh?
There is no bar lordship.
I can clarify then. The same thing. Earlier rejected.
New ground lordship.
Huh?
New ground is lordship and in the second.
You are treating it like a second bail application.
Yes.
Is that maintainable?
That's.
You look into it, Mr. Goswami. I'm posting it after reopening.
Lordship.
As prayed for by Mr. DP Goswami, APP, the matter is fixed after 3 weeks on a date to be fixed by the registry to enable the state respondent look into the maintainability of the IA.
So one submission lordship in the maintenance lordship.
No, nothing in the meantime. Yes.
Yes, lordship.
None appears for the petitioner list after 1 week on a date to be fixed by the registry. Make it after 2 weeks.
Lots of delay of 5 days loss.
Days.
Yes, loss.
Notice has been issued or not? State, only state or?
No, NI Act, lordship.
Enact law.
Oh, then notice has to go.
Yes, Lord.
Issue notice, registered post AD, returnable 3 weeks.
Obliged, lordship.
29 days.
My lord,
Notice has to go.
my lord, the under section 324 was convicted only 2 years punishment.
That's all right, madam, but this is a condonation.
Yes. My lord, 29 days.
Then Notice, registered post AD, 3 weeks.
I am appearing legal aid counsel. my lord.
Next. Iman?
May you please, Your Lordship, the condemnation there is only for 5 days, Your Lordship.
Notice issued or not issued?
Is a
First time?
Yes, Your Lordship. Your Lordship may please, may condone the delay only for.
No, even if it for 1 day, I cannot condone without hearing the other side. Why have you not come in time? Notice, registered post AD, 3 weeks. Yes.
Oblige, Your Lordship.
Yes, Mr. Majumdar?
Lordship, item number 57 may I kindly take first because I filed an IA. What
No,
happens
but in 57, there is no IA. You have
Lordship,
filed today.
I filed it yesterday and today by sleep, I bring the same. What happens, Lordship, in this case?
Gutta petition no dibo, huh? What is the prayer in the IA?
Lordship, in the prayer in the IA is Lordship, page 13, Lordship, 14.
Page?
Page 14. There was they filed a revision petition against the award of maintenance and shareholder house Lordship as a letter, share house. And in that case, Lordship, page 14, this honorable court, Lordship, pleased to stay the DB case, Lordship, for which she is not getting any maintenance, Lordship. 5,000 rupees, Lordship.
What is this? What is happening in the main cases?
Main case, Lordship, even they have not
Who is appearing for the other side?
Petitioner, Lordship, even did not take any steps, Lordship. I have obtained the certified copy of that petition, Lordship.
No, in item 57, you were the respondent.
Respondent, I filed.
Where is the respondent counsel? The names are shown.
Petitioner shown, Lordship.
Main petition to sir?
Even Lordship, I pray, Lordship, I respectfully submit, Lordship, they have not taken even steps after obtaining the.
But you see, the IA has come up for the first time.
Lordship.
That too,
Lordship.
it's not
In
in
the
the
main case. 150, 2025, 5/5/2025, this honorable court pleased to issue notice, Lordship. They have not even taken any steps, Lordship, to me, Lordship. And subsequently, while they inform the learned court below that they have.
It is
filed-
5/5. Yes, are here to sir? The other one?
Other one is I filed a petition for 56 is the petition for enhancement of maintenance allowance, Lordship. In that case also, they have not appeared, Lordship.
Okay, I'm having this IA on the reopening.
Lordship,
Should notice fixed on
fixed date may be kindly considered.
Huh?
Fixed date may.
It appears that Mr. B.A. Acharya has is the engaged counsel in the accompanying criminal revision petition. Mr. So-and-so is is allowed to serve a copy of the.
I already.
Mr. Counsel, please hear the order to furnish extra copies of the IA to so-and-so. List on so-and-so for further consideration of the IA. Yes.
Much obliged.
Corresponding number.
Mr. Sorena, you were supposed to make some clarification in this matter.
My lord.
Right.
Regarding my lord, lordship, last time my lord made an query, my lord.
Huh?
Regarding prayer number 2, my lord, my lead petition.
What was it?
Why, my lord, there is prayer for my lord?
Not in question to see that. Yes.
Let's do one thing, Mr. Sorena, right now, because since today I am not taking the, I was taking a criminal matter.
My lord.
After reopening, I shall be sitting at ISOL, so I can have this matter fixed through video and we can have it on the Tuesday or the Thursday of the reopening week. Mr. Das, Tuesday or Thursday of the reopening week?
Your lordship may come back from ISOL and do it, why not? physically, my lord.
I can do that, but it is
That would
easier
be-
to hear there, and because I think all the written arguments are already there.
Yes,
Only a
all
small
right.
clarification is needed from Mr. Soronia. We can hear that and
Yes, 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 yes.
I think that can be done
Yes.
with it. Otherwise, I don't think there is much to be.
Yes, your lordship has
he has
already
finished
heard the
their part. Only Mr. Soronia was supposed to come back with that
And
clarification, isn't it?
Yes, ma'am.
Oh, all right. Then we are fixing it on Thursday? Reopening on
Thursday,
Thursday?
after reopening.
Yes, yes, yes.
Yes, yes.
That will be
Yes.
which date?
A
17?
date.
Okay, fix on, no, list on 17/7/2025 through video conferencing mode for the hearing. It will.
Seven.
This is that finance officer's appointment.
Yes, your lordship. We have already submitted our written submissions and the finance department has also submitted.
All right, this is Tuesday, video conferencing mode, reopening Tuesday. Okay? Get a low jump there. Yes. Mr. Singha, in your case, both parties have already given, isn't it?
Yes, your lordship.
For dictating judgment in court.
Deeply obliged, your lordship.
I'm appearing for the respondent number 2 amicus curiae.
Sorry?
I'm appearing for the respondent number 2 amicus curiae, Lordship. My senior is on legs.
All right, after vacation. List after vacation. At a date, give a date.
Date may be fixed, my lord.
As prayed for, huh? Yes.
The first July. In this case, my lord, I'm in jail, my lord. 2 years, 3 months. I'm in jail.
You are in?
In jail, my lord, 2 years, 3 months.
2 years, 3 months. The POXO.
My lord. No, my lord. Yes, my lord.
Yes,
POXO.
what no?
POXO, my lord.
40, this is the item number 40?
47.
47. So thus?
Lordship. So respondent number 2 should appear, lordship. It is a POXO case.
POXO, right? So notice was issued.
Yes, my lord, received. They received, my lord.
Name also reflected, lordship.
Name of?
Name is also reflected, lordship.
Who is appearing? Otherwise, we'll appoint someone.
Check.
Whose name is Mr.
May I close?
Yes.
My lord, this application has been filed under section 482 of CRPC. My lord, for quashing of FIR and charge sheet.
Yes, where is the FIR?
Lordship, FIR may be seen at page 14.
Read.
With due respect, I would like to inform you that on 13/8/2022, on way to Bihuguri SS School, Sri Pritam Savasi, son of Suresh Savasi of Nahoroni Tea Estate, met me at Badormari at around 8 a.m. and forcefully lifted me on his motorcycle and took me to Tezpur. Thereafter, he wrapped me in a hotel room with an enticement of marriage. After that, at 7 p.m., he dropped me at my elder sister's house at Gurahmari.
You want quashing of this FIR?
Lordship.
The ingredients are there.
My lord, there was.
Be in his hotel room with an enticement of marriage. Drop me at my so-and-so.
What happened, my lord? There was love affair.
This court will not go into that right now, whether there was love affair.
My lord, she is examined, my lord, by the trial court. Her statement in 161, 164, and the statement before the court, all are contradictory, my lord.
Then you get an acquittal.
It is a case of consensual sex, my lord.
Mr. Counsel, how can this court now determine the question of whether the sex was consensual or not consensual?
My lord, I'll say.
By convicting you.
No, my lord, I am
This
satisfied,
is
your
a
lordship.
quashing petition.
Lordship.
Please show me which authority is there to state that in a quashing petition, this court can now look into and ascertain whether the allegation is false or not false.
My lord.
Please tell me.
My lord, in the case of Shiv Pratap Singh Rana, my lord, the Honorable Supreme Court my lord, decided a case and quashed the proceeding.
No, no,
While
that could be in the facts of that case, but where is it said that I
Facts
can
are
look
similar, my
into
lord.
whether, Mr. Counsel, please be clear. Please be clear. You're an officer of the court.
my lord,
Give me an authority to show that I can look into whether at the stage of quashing, whether the sex is consensual or not consensual.
yes,
Because if the allegation is there, then I have to accept that on the face value, and this is the law. This is well settled from Bhajanlal. There is no change. If this was not there in your
my
FIR,
lord,
you don't even have to make so much effort. I would have quashed it right away.
my lord, can it be on after vacation?
No, no, I'm dismissing it. Why should I keep this matter pending? Yes, Mr. Goswami?
Trial is going on, prosecution, after 9 witnesses, 1 witness is examined already.
9 witnesses already examined.
1 witness is coming out of 9.
No.
But this is a quashing petition, isn't it?
As far as scan copy of.
Scan copy
So
is
that is also not material for the consideration of a
Not-
quashing petition. Yes, Mr. Nawaz? You are for the informant?
Might just for the respondent number 2.
Yes, please.
Yes, ma'am. So apparently, the allegation is that on the false promise of marriage, sex took place, ma'am. So now whether consent is disputed or not, that is a disputed question.
Matter of trial.
Trial, ma'am. And victim has already been examined. So these issues can be agitated. to the trial court.
Absolutely. So I don't think anything is there.
My lord, victim,
Sorry. Yes, please take down. All right, Mr.
M. Ali, my lord.
M. Ali, learned counsel appearing for the petitioner. Also heard Mr. This is item 48, na?
48.
Also heard Mr. D.P. Goswami, learned APP for the state, and Mr. S. Nawaz, learned amicus curiae representing the respondent number 1, informant. By way of this petition, under section 482 of the CRPC, petitioner is seeking quashing of the FIR dated 2/9/2022 by Tejpur PS case number 949/2022, registered under section 420/376 IPC, and the charge sheet number 1038 of 2022 dated 30/12/2022, submitted against the petitioner before the learned Chief Judicial Magistrate Sunitpur Tejpur. The brief facts of the case is that paragraph number 3. Paragraph 3. Accordingly, a case was registered. This is already asked. After registration, the police started investigation, and upon completion of the investigation, charge sheet was submitted on 30/12/2022 against the petitioner under section 376/420 IPC. Aggrieved by the aforesaid, the present petition has been filed seeking quashing of the aforesaid FIR and the charge sheet. Stop. Mr. So-and-so submits that the allegation of sex is consensual, and therefore no offense under section 376 IPC is made out. He further relies upon the decision of the apex court in Etodiok in the case of Shri Shiv Pratap Singh Rana versus State of MP in Criminal Appeal number 152 of 2023, and Mandir Deepak Pawan versus State of Maharashtra in Criminal Appeal number 442 of 2022. Duta apex court verdict. Heard, perused. The instant application being for quashing the FIR apt to reproduce the FIR at the outset. Page 14, A to A. The FIR dated 2/9/2022 reads as under. Reading of the aforesaid FIR, it is apparent that the informant has clearly alleged that on 13/8/2022, while she was on her way to her school, to Bihuguri HS school, the accused stroke petitioner met her at around 8 a.m. and forcefully lifted her on his motorcycle and took her to Tejpur. It further appears that the informant has also categorically alleged that the petitioner accused has raped her in a hotel room with an enticement of marriage, and after that he dropped her at her elder sister's house and ran away. The aforesaid allegation on the face of it appears to constitute a criminal offense. Whether the sexual act is consensual or not is a matter of trial, and this court cannot at the time of considering the issue of quashing the instant FIR can look into it. That being so, there is no merit in the instant criminal petition. Accordingly, the criminal petition stands dismissed.
Okay.
Kindly taken up this matter after vacation, my lord.
Huh?
After vacation.
As prayed for, list after 3 weeks and a date to be fixed by the registry.
Obliged.
Your lordship may have to appoint a new amicus for
the Mr. Das, would you like to represent the informant in this case? All right. It appears that this Disoikya
is recently selected for the post of additional district judge, your lordship.
Acha. It is submitted at the bar that earlier appointed amicus curiae is no longer practicing.
I can't submit, your lordship, but she was
it has been recently selected
for the post of additional
district and session judge. It further appears that while this matter was called, the MS so-and-so is not present. Be that as it may, since the offense involved in the instant criminal appeal arises out of the POXO Act so-and-so, this court, for the interest of justice, appoints Mr. S. Das, Learned Counsel, as an amicus curiae to represent the respondent number 2. Let a copy of the appeal memo along with the other documents be furnished to him within a period of 3 days from today.
Your lordship may fix a date.
Yes, when? List on such and such date.
Vacation, your lordship.
Yes, give a date.
Yes. Deeply obliged.
May I please, your lordship? Lordship, this application is for quashing of the FIR and the proceeding arising out of that FIR.
Arising out of?
That FIR. Because already search sheeted and it is pending for trial now. He is on bail. Lordship, FIR is at page 24. The guy.
Yes, page?
Page 24.
Page.
Yes, lordship.
Rupok. তেওঁলোকৰ নহয় এসিস্টিং কৰিবলৈ কাৰণে অসুবিধা হৈছে কাৰণ এইখন এইফালে আছে এখন এটা একেটা লাইনত কৰাই দিব নাই কিয় হৰো এটা ঠিক কৰি দিব লাগে because the assisting counsels are not being able to assist properly from there because the arguing counsel is ahead. It is not correct. I have been noticing throughout they are all getting up and assisting. It's inconvenient for them. So you ensure it is in the same alignment.
Lordship, I have prepared a small brief.
Yes, let us see the FIR.
Yes, Lordship. Lordship, FIR this is an application addressed to the Chief Judicial Magistrate. Lordship, it starts from page 24. to the Chief Judicial Magistrate, Kokrajhar, BTAD, Assam, from Rajkumar Prithviraj Dev Mes, such and such, Director of Northeast Heritage Foundation, son of such and such, Ishwar. The prayer for providing forwarding direction to the OC Kokrajhar Police Station for registration of a case under relevant provisions of law in regard to the undermentioned. With profound honor, the undersigned, being the concerned citizen, would like to earnestly request you to draw your kind attention towards the submissions along with the facts and circumstances mentioned hereinafter. It has come to my notice that Sri Dulal Bora, son of Deven Bora, Rajiv Gandhi Pot, Koinadhara Tiniali, house number of such and such, P.O. Khanapara, P.S. Bosisto, Guwahati, Assam, who rather claims to be an RTI activist, allegedly possesses disproportionate amount of assets of the property in comparison to his genuine source of income. It undoubtedly alarms a question as to how, being an RTI activist, he could possess such enormous mass of economical assets. This would either apparently indicate one of the two facts: the source of income by blackmailing / extortion in the name of withdrawing RTI petitions, or unrevealed source of income. From the relevant sources, I am acquainted with
detailed FIR.
Yes, Lordship, the FIR is detailed.
Very
But
detailed.
what is the source of the FIR and what has been
not required to be
Lordship,
disclosed, Mr.
now-
Counsel.
Lordship, that is there.
Why that source needs to be disclosed? He's given detail.
Lordship.
If it was simply a suspicion because you being an RTI activist, you have a lot of card, that one could have understood. But so much of detailed allegations are there.
Lordship, the
Now
detailed
you
allegation-
want quashing of this FIR.
Yes, Lordship, quashing of the FIR and the search sheet, because the search sheet, what the
Right after vacation.
Yes, Lordship.
As prayed for a list after so and so date did you. I am not convinced, Mr. Counsel, you'd have your.
Lordship, I will convince you, satisfy your Lordship, because it is.
All right, you enjoy your vacation. We'll hear you after the vacation.
A date may be given kindly. Not surprised.
23rd, Lordship, I have some difficulty. I will be out of station.
Please say when you want it.
Lordship, if it could be on 29th.
Not.
If you oblige, Lordship.
Yes, Mr. Sheikh.
My lord, here also, my lord, some time will be required, so.
All right, as prayed for by Mr. M.A. Sheikh, learned counsel appearing for the petitioner list, you want a particular date?
My lord.
After 3 weeks?
My lord.
Or a date to be fixed by the registry? Okay.